Good afternoon, everybody. Whoops, I think I got everyone. There we go. Can you all hear me?
Yes.
Oh, well, I turned on a speaker and it doesn't seem to be working. Trying to Bluetooth this. Here we go. Let's try that. It's not working. Okay, give me a second. I had it all set up working and now it doesn't seem to be working. All right. Tommy, say something.
Hello.
It's still not working. Gosh darn it. Give me just a quick second, folks. Why isn't this working? I don't know how to get out. All right, well, you know what? I'm just gonna have to live with the regular speaker that we've got today. All right, so we're here today on the wife's request for attorney's fees in case number 18DR389. Is everybody in the room who needs to be in the room today? I see Ms. Gonzalez, I see Ms. Sparkman, Mr. Schutt, Mr. Stein, Ms. Beauvais, and our clerk, Tommy. Anybody else that's supposed to be here today, folks? No. Okay. All right. So before we proceed, first of all, anybody who's not testifying or giving evidence today, if you could please mute your microphone, because if you don't, a lot of times because of Zoom, we'll get a lot of feedback. So that would be very helpful. Also, I have received lots and lots of exhibits, so I want to make sure that I know what we're using today. And so first of all, I have the exhibits that were given to the court from Ms. Gonzalez. And these were given to the court at the date of trial. They are date stamped as filed 8/17/20, and they consist of, let's see, how many exhibits do we have? It looks like there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. There are 14 exhibits that were from Ms. Gonzalez. Ms. Gonzalez, are those all of your exhibits, ma'am?
This is Mr. Stein here speaking for Ms. Gonzalez. I'm her attorney.
Okay, I was thinking Ms. Sparkman was, but I knew there had been some substitutions. So, all right, Mr. Stein. Yes.
I'm representing her post-judgment in the divorce.
Yes, sir.
And I did an amended exhibit list. So the one you're talking about from August, I amended it to add a 15th exhibit, which was just the final judgment. That was filed on 1/23/2021.
Okay, let me find that. Is that the amended petitioner's exhibit list?
Yes, Your Honor.
Okay.
Then, because I had a few things occurred to me, and I did a supplemental exhibit list just today, adding 3 more exhibits. But I misnumbered it, so I had to do it again with a correction. So there's also, so ignore the supplemental one. There's an amended supplemental that I just sent to your assistant that has the correct numbering, because I had misnumbered.
That's what I have. I have the original amended petitioner's exhibit list 1 through 15. Then I have a 16 through 18 that looks like it came in today. Yes, and then all of the exhibits appear to be attached. Oh God, I hope they are. Well, the first page says petitioner's exhibit 15. So I hope they're not all backwards. Oh my goodness. They look like they are, I don't know what order these are in.
I can resend them. I do have them in a format that's the right order. I'm not sure.
Okay. Let me just see if I can figure this out. Oh, okay. It looks like my assistant put exhibit number 16 on top because that came in.
That was my second batch, 16 through 18.
She may have just given me 16 through 18. Let me see, that's 16. $17 and $18. All right, I'm going to put these so that they are in order, because otherwise it'll make me crazy. So let's paperclip these. 16. 16, 17, and 18. Now, has the clerk been provided with these exhibits?
I did file them.
You did file them, okay.
Now, I was last minute on the last three, but the previous first 15 were filed, I think I just said on the 23rd.
Okay, thank you. So there's 17 and there is 18. All right, so now I need to find numbers 1 through 15. And those are probably in a stack. Okay, the final judgment for dissolution of marriage is marked as Exhibit 15. That must be an old 15. Is that right?
That's correct. I put it in there because I just wanted to have a reference to the issue we're here is a paragraph in that final judgment about the reasonable attorney's fees.
Okay. All right. Well, I think that actually the law says that it has to be reasonable attorney's fees. So that's why the court puts reasonable attorney's fees in its rulings, because 6116 says reasonable attorney's fees, I believe. I haven't looked at it in a long time. All right, let me find exhibits 1 through, oh, this is Ms. Sparkman's exhibit, so that's different. Let's find 1 through 15. I'm hoping that this is it. 1 through 14, I mean. All right, there's one. I may actually have all of it. 1, 2, 3, 4, 5, 6. 13, 14. All right, so I have 1 through 14, and then 15. Let's see. 15 is the final judgment, is that right?
On mine, yes, Your Honor.
All right, thank you. 16 is, I've got 16, 17, and 18. All right, we're good to go. And I'm just gonna get rid of the rest of this because I don't need it. And have this all. And there we go. Okay, got all those. Then I have a stack from Ms. Sparkman, it appears, that is numbered 1 through 13. And this is dated the 26th of January. And these are all your exhibits, Ms. Sparkman?
Yes, Your Honor, they are.
Thank you. Are there any other exhibits that anyone intends to present today other than Ms. Sparkman's exhibits and then the other exhibits from the former wife?
Your Honor, Darren Shute on behalf of the husband. Yes. I have case law I can put on using the screenshot, but I guess that raises a question I have, because typically in these cases, the party who is seeking the fees comes in hand with their attorney, knowing what they're looking for. But in this case, I believe it was just prior to the trial starting, Ms. Sparkman wasn't allowed to withdraw, but she was given chargingly by the court. So I think there's a huge first question that has to be answered is, what is the court going to grant in fees? Because I think there's two standards on fees that are before the court. The first one being, what is the contractual relationship between the former wife and her former counsel, and what fees are owed there, because they may be different than reasonable fees. For example, in this case, the former attorney is in Tampa, would have to drive to Naples 3 hours and back to Tampa 3 hours, which may be a contractually obligated fee for the wife, but it's not a reasonable attorney fee for the law. And additionally, she may have agreed, I'm going to pay you to file motions, whether you win or lose. Florida reasonable attorney's fees standard. That's not a reasonable fee if you file a motion and lose it. There's case law that says the court shouldn't award it. So kind of like usually you have entitlement amount bifurcated. Court has made entitlement, but we have this odd situation where the wife is disputing the attorney's fees that the former counsel is looking for. And I don't know if that's going to conflate the hearing, because I have different arguments based on different legal standards than what the former wife's current counsel and prior counsel are going to argue, because they are looking at it from a contractual basis, where the issue of what the court awards based on its judgment, as the court noticed, is based on the statute and the Florida provisions as to what are considered reasonable attorney's fees.
That's true, which is why I wanted to have this hearing. And I knew that Ms. Gonzalez and her former attorney were at odds, and I didn't know whether they would continue to be at odds after the hearing or not, but apparently they are. And this matter is becoming extremely stale. The case was tried, a long time ago, and I've been trying to get this attorney's fees motion heard. So I kind of look at it as, I kind of think I need to hear everything, not only from Ms. Gonzalez and Ms. Sparkman, but also your position, Mr. Schutt, with respect to the former husband's position on what fees would be, assessed against him and whether they're reasonable or not. So I can't change the relationship between Ms. Sparkman and Ms. Gonzalez, whatever that is.
May I
Ms.
briefly?
Yes.
Just, I don't disagree with most of what counsel just represented. I also provided case law to the court for 3 cases, but one does squarely address when there's a dispute on the fee itself, but where there's a charging lien that has also been granted in the case, and how to, when the counsel comes to enforce that. I don't at all disagree that there still has to be a reasonableness regardless of the charging lien being granted in this case. But true to the point being made, this case then kind of diverges and becomes a little bit more complex because of the timing of when it was granted and obviously the situation. I will say, without getting into the actual substance, I took the court's guidance on the last day of trial. You did speak to both myself and Ms. Gonzalez, urging us to try to come up with some sort of agreement. I did make my best efforts. I don't think Mr. Stein will disagree with that. We were unable to reach a resolution.
Okay. All right. So in light of that, we will have the hearing today. Mr. Stein, this is the former wife's request for the attorney's fees. So I believe you would be the person to present the evidence and testimony first. Let me first ask, does anybody disagree with the exhibits that have been provided to the court? Are they going to be objected to? Is there any agreement as to whether they'll be admissible or not?
May I speak on that point?
Yes, ma'am.
Again, because this is a little bit of a different situation, I noticed that the exhibits that the former wife's attorney provided are not redacted in terms of email communications. My obligation is obviously different, regardless of the fact that she is a former client. So the exhibits that I provided are in redacted form. My question would be, if there becomes, which I'm hoping there's not, but if there becomes some sort of dispute on the content, and I think some of our emails are overlapping that we provided to the court. But again, mine are all in redacted form. I'm hearing background noise. I've at least taken it to mean that on the email communication subject matter of what the former wife has provided on her own, that there is a implicit waiver of attorney-client privilege related to those communications, since she's both filed them with the clerk and provided them to present at this hearing.
Well, I would say that if the wife is planning to disclose attorney-client privilege communications, that would affect a waiver, because you can't have it both ways. You can't say I'm entitled to the attorney-client privilege and then present all the attorney-client communications without waiving it. I mean, I just don't see that that's just kind of how it works. If you disclose it, it's not privileged anymore.
On those particular disclosures, wouldn't be
right, on those particular disclosures, correct.
Understood.
Okay. All right, so Mr. Stein, you ready to proceed?
Yes, I am. I'm happy to start. I know Ms. Sparkman had asked if she could go first. I'm happy to go first if she wants to. I would allow it if
That's
you
okay with me too. That's fine with me too. Whatever your pleasure. I was just thinking that because she's the petitioner that you would want to go first, but Ms. Sparkman, if you guys have talked and you want to have her go first, I'm fine with that as well.
I appreciate that, Mr. Stein. I have a CLE that I was going to be presenting at 2:15, so I appreciate it. My portion is going to be very short, but of course that's dependent upon either counsel's cross of my presentation or examination.
Okay.
Honor, if I may, please the court and proceed quickly with a brief opening.
First of all, everybody who's going to give testimony today needs to raise their right hand and be sworn, including you, Ms. Sparkman, if you're testifying. You swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Ms. Gonzalez, you're muted. You need to unmute your microphone.
Yes, I do.
Okay. Court will take notice that both Ms. Sparkman and Ms. Juliet Gonzalez have been sworn in. All right, Ms. Sparkman, you may proceed.
Thank you, Your Honor.
Thank you.
Your Honor, as we've already mentioned and the court is aware, I filed a notice in motion of attorney's charging lien on February 10th, 2020. That notice in motion of charging lien was filed preceding the start of a final trial in the dissolution of marriage in the case number 18 DR 389 Gonzalez v. Gonzalez. The former wife, Juliet Gonzalez, was my client from the date of retention, which was by signing of the retainer agreement June 25th, 2019, through to the date of the withdrawal that the court ultimately signed in February of 2020. At the conclusion of that final hearing on February 12th, 2020, the court granted the charging lien to the extent that there were fees that were incurred and owed, and the fact that the charging lien statutory requirements were met, meaning the charging lien was perfected to the extent that it was legally permissible. It was encompassed within the signed retainer agreement within paragraph 4 and 5 of the signed retainer agreement that Ms. Gonzalez signed. It was also subject matter of several email written communications between my firm, my office, my staff, and also directly with myself, between myself and Ms. Gonzalez. Hence, that charging lien was properly entered by the court. The question here today, and my attorney's charging lien states, at the time that this was filed and entered by the court, the balance owed at the time of the filing of the notice was $27,075.80. That's contained in paragraph 4 of my attorney's charging lien. That is also supported by the itemized fee statement, which is in my paragraph, strike that, which is my exhibit 10 and 6 of the exhibits that were filed on January 26th. After the conclusion of the final trial, there was an updated amount that was also reflected in my fee affidavit, which is included in this exhibit list that was filed yesterday, and that would be exhibit number 5 for the court's reference. That fee affidavit was also attached to the notice in motion of attorney's charging lien has been previously filed with this court. The anticipated amount at that time that would have been incurred was a prospective request in the amount of $7,000. So at this time, as it stands, Ms. Gonzalez owes my firm a total amount of $34,075.80, and that's what I would be asking the court to award today.
Ms. Sparkman, when was the order granting the charging lien? I just don't see it.
There was not, and if you look at exhibit number 12 of my exhibits, I sent an email, Your Honor, after there was the entry of the final judgment, as the final judgment was silent on the issue of the granting of the charging lien and the setting of the enforcement, which is typically, at least in my experience, what I've seen. I inquired, as we did have a oral pronouncement by the court, and the email response was that the issue would be addressed when the fee hearing is scheduled.
Okay, that makes sense. All right, thank you.
Welcome.
All right, you can proceed. So $34,075.80 is what you're saying she owes you, correct?
Today, yes.
Today, thank you. Okay.
And that concludes my presentation, Your Honor.
Okay. Mr. Stein?
Thank you, Ron. I have some questions for Attorney Sparkman. And I'll try to be quick and brief.
First of all, before you start, are we admitting 1 through 13, which Ms. Sparkman has provided to the court, those exhibits?
I have no objection.
Okay, so exhibits number 1 through 13 will be admitted.
When I was rolling through mine and the one I was provided earlier, I'm not sure if it's complete. There may be pages missing.
You're breaking
What
up.
was previously
He cuts out. Is anyone else hearing it or only me?
When I scroll through Exhibit 6 that was provided this week, it appeared that there may have been some pages missing from what was previously or what I had used as a working copy.
And that's the redacted invoice of the final amount owed.
Right, it just seemed like it skipped a couple pages. I'd have to go back to it, but because I had numbered my pages and the exhibits aren't numbered.
Okay, there's also a identical copy that just happens to be attached, and just to be in for purposes of completeness, on exhibit number 10, there was an email that was sent to Ms. Gonzalez with the invoice. So rather than just send the email or submit the email, I also attached that. So you should have that as well.
Okay.
My exhibit 10 only has an email. It doesn't include any copies of anything. Just has a February 8th email, no billing statements or anything.
I may be in error, but that's fine. I have no objection to the exhibits.
Thank you.
Okay, so exhibits number 1 through 13 will be admitted. All right, Mr. Stein, you can proceed.
And Your Honor, before I don't want to forget, can I offer my exhibits into evidence now, 1 through 18 from the?
Does anyone have any objection to Attorney Stein's exhibits number 1 through 18?
No objection.
No objection.
Okay, so the amended petitioners exhibit list, which are 1 through 15, and then the amended supplemental exhibit list, which is 16 through 18, all of those exhibits 1 through 18 will be admitted. All right, Mr. Stein, you can proceed.
Okay, thank you.
Thank you.
Attorney Sparkman, when you first were engaged by Ms. Gonzalez, was this a retainer agreement or a flat fee or something else?
This was a retainer agreement. There's only one signed retainer agreement that I've ever had between myself, or my firm rather, and Ms. Gonzalez. And that's the retainer agreement that was attached to the charging lien presented in this case, and part of the exhibits that was signed June 25th, 2019.
And was there an hourly rate involved?
There was.
What was that?
There was, yes, sir.
I'm sorry, I should ask it better. What was the hourly rate?
$3.50 an hour.
And were there other hourly rates beside that you mentioned?
The paralegal staff hourly rate and any associate attorney's hourly rate.
Okay, and did Mrs. Gonzalez pay you a non-refundable retainer with that?
She did. So paragraph 3 outlined, it sort of outlines, that's the general retainer agreement I use in any of my family law cases. So it was a $10,000 retainer to be paid at the time of the signing of the retainer agreement.
Okay.
And then the rest of it outlines the managing partner's hourly rate, the associate attorneys, and then the paralegal's hourly rate. So $350, $300, and $100.
Okay, and did you in fact follow this agreement and bill your client hourly in this case?
I did. So in any case, I bill hourly. I think it is our obligation to keep track of the time that's expended on the cases that we work on. So I do that regardless of whether there is an actual flat fee retainer or an engagement retainer. In this case, after the first hearing that I attended, after I was retained in June, this case was set for trial at the time that I was retained. So there was a pre-trial conference and there was a final trial date that was set. Upon going to that hearing, that very first hearing, which back then was in person, and learning at that stage, and I was maybe 5 to 7 days in representation by the time I was provided all of the former counsels. Ms. Gonzalez was represented formally with the case file. When we discussed what it would take for me and the amount that I foresaw that Ms. Gonzalez would incur, when I laid out what needed to be done prior to the trial date that was already set, Ms. Gonzalez conveyed to me her dire financial situation, which she was already in at the time that she hired me. The posture of the case was not where it should have been, in my opinion. That's what I had conveyed to her. And there were many things that I thought that needed to be done. And the fear was that she was going to incur these fees leading up to trial, and she wouldn't be able to pay it and would be at risk of not having counsel. I offered, we had a discussion. When I say we, myself, Ms. Gonzalez, and her boyfriend, Ed, on the phone, and we discussed every step that I would need to take and the amount that they could foresee getting billed. And in lieu of that, I offered a $25,000 payment to be made that would be applied to what was already paid. And so that would take us through to that trial. And I promised her, and I put that in writing to her, that I would not bill her between all the steps that I laid out of what we would need to do to get to the point of being trial ready. And I honored that. Unfortunately, and there are aspects that I can't get into because of attorney-client privilege, but there was a shift that had to happen, not by my volition, but by Ms. Gonzalez's own volition, that caused the trial date to be continued to this trial date that we ultimately had in February. Immediately upon that decision that was made to not go forward on that first trial date that was set, I notified Ms. Gonzalez in writing, had multiple phone conversations. If I were to do a screen share and just put in the email addresses, your Outlook shows you the number of emails. There are 575 emails between myself, my firm, my staff, and Ms. Gonzalez. Notifying her, not 575, notifying her, but we notified her repeatedly that we are going to revert to this hourly billing, or she needs to pay X, Y, and Z for us to continue. I was basically told, we will get the money, we will get the money. In a nutshell, I was told that I would be paid. I was told that they wanted to see a billing statement, that they could not believe that a couple of emails, I think if you look at exhibit number 7, Ms. Gonzalez actually says something to the effect of, I can't believe a couple of emails has resulted in $35,000. So, and I think my itemized billing statement shows the reality of all of the work that was done on her behalf. So going back to answer your question, there was a concession and a proposal that I made out of courtesy to Ms. Gonzalez after extensive discussions on the issue and after things that Ms. Gonzalez herself wanted to be done in preparation of this case. And there also came a point thereafter that a complete billing statement was provided showing exactly what had been incurred due to the lack of payment and Ms. Gonzalez's own lack of follow through.
I just have a few follow-ups. You said
Sure.
a lot. So when you collected that first $10,000 as part of the retainer agreement, Does that get deposited into your operating account? Does that go into a client trust fund? How is that handled? How do you treat that?
So typically all of my retainers, anything just goes into the trust and then we transfer it over. I mean, as a matter of course, if what you're asking me, so this case wouldn't have been any different. I mean, it's just an automatic.
So the 10,000 went into your attorney,
Originally would have gone into my trust, but at some point, yes, it was transferred to my Sparkman Law operating account.
And then do you send her a billing statement before you make that transfer?
I don't think in this situation I would have sent her a billing statement at the transfer.
Is there any particular reason? I thought that was a requirement.
No, I mean, my retainers usually spell out the time frame of when I provide quarterly billing statements. I also have a client portal in which the clients know that they can go on at any time if they log into the My Case, and they can see in real time what the billing is, what the transfers are. So, I mean, that's kind of how.
Okay, so when was the first time you created any itemized billing, whether you put it on the portal or sent it directly to the client? What was the first time in this case?
The first time the billing statement would have been created is the date. If you look at my itemized statement, I mean, the actual invoice is created, not invoice, that's not the right word. The statements are created on the date of hire so that, you know, no matter what's done on the file, My Case is keeping track of everything that's done. So it would be created on the date that the file was opened. Now, if there are things that are updated, for example, with text messages, it's not something that I'll be working, let's say, on a motion and have my case clock running at the same time. So text messages, I would gather whether once a week or every 2 weeks or 3 weeks or whatever it is to go back and itemize all the text messages or emails if I'm doing it by my phone.
Okay, so in looking at your Exhibit 6, if everybody can refer to that, I'm reading that it says at the top there's an invoice date of February 8, 2020, and the billing time entries begin April 23rd, 2019, and they continue on for looks like months of billing until I believe the next statement, it looks like it goes up until February. So is that your normal practice to do the billing in that manner?
The invoice date will show that invoice date, the date that you printed. So if I were to go on right now to print an invoice, it would show today's date, but that doesn't mean that that's the date that the invoice is created.
Okay, if we look at Exhibit 4 of my exhibits, and I just have to find that real quick. Do you see that, Attorney Sparkman?
Do I see your Exhibit 4?
My
No,
Exhibit 4, which is an email between you and this other, it looks like an assistant, and Ms. Gonzalez. Do you see that?
I don't have your emails up because I think I'll have to leave the screen here. Can you share your screen? Or I could pull it up on my phone.
Yeah, I'm not good enough to share it yet, unfortunately.
Okay, give me a second. I will pull it up on my phone so that I don't lose you guys on the screen. Is that okay?
Yeah, it's fine. Fine with me.
I mean, you could read it.
Okay. So
I've already accepted all the, yeah, go ahead.
Okay, so I'll try to read the pertinent part without skipping it. So start.
Sure.
It's from you, it appears, and essentially it's to Ms. Gonzalez, and it says, quote, "As I explained to you on the phone, I've been representing you for approximately 10 months. What your fees paid for have been 10 months of representation. You were not billed during this time due to your flat fee." So can you explain what that means in the context of what we've been talking about?
Yeah, I mean, I just said it. We entered into the agreement in June. I went to that first hearing. She was represented by former counsel. There was a lot of upheaval in that case up to the point that when I took over, and we had a discussion, and they were afraid because every billing conversation was with Miss Gonzalez and her boyfriend, that they would not be able to afford taking this to final trial and preparing, at least in the manner that I had offered, that I thought would be necessary. The getting the depositions completed, the forensic evaluations. There was many things that we had discussed, and as a result of that discussion, they both agreed, as did I, that I would suspend billing to prepare for this trial that was set. I included that order. Also, it's exhibit number 2, the first order sitting trial. So that discussion was had right after that pretrial conference.
Okay, so I just want to follow up. I'm going to read. I'll continue reading. I won't skip anything.
Sure.
Just some of it probably doesn't need to be said, but I don't want to give the whole context. I'm just going to continue. Your case file was messy, disorganized, chaotic, and is large. In order for me to make sense of what is what, it took time. I cannot continue to do so without adequate fees in place. I will submit a billing statement to you that will take us time to get to you. However, if my staff takes the time to generate that for you, based upon the records of work done in your case, if there is a balance due, it will be due immediately, and it will be billed by the hour at my hourly rate. We did not bill you hourly to save you the billable time and costs as your case was set for trial when you first hired me. I can guarantee you that if we generate a billing report, it will far exceed the fees paid. So with that, I just want to ask a couple of questions on that. So it looks like as of January 22nd, 2020, you were not billing her hourly. Is that correct?
If that's what the date of the email is, we had ongoing discussions about payments. We had ongoing discussions about, okay, if she didn't pay another trial fee that was a flat fee, how much would it cost to depose this person? What would I charge and what would I accept if we did X, Y, and Z versus this? And there's emails to that effect also, that I think there was an email of $7,500 for, doing whatever it is I outlined in that email. On that date, when I say generate, Miss Gonzalez was adamant that there is no possible way that she had incurred that much in fees or that she should pay any additional fees. So my responses to her were that, yes, I was still honoring the $25,000 that I had originally offered. I had honored that, but she had not paid from that date that trial was continued to the date that I wrote that email. There was no funds that were paid for any work that was continuing to be done. And she continued to ask in what method, if I would accept this flat fee towards this, and if it was a billing, would I accept a payment plan on the billing? So that email was sent essentially to say, or my intent was to say, there is going to be a balance due. And once you receive that billing statement, I do expect that balance is paid. And I mean, that's it.
I understand. So, and what I'm trying to get at, I'm going to go back. So that initial $10,000 was paid. Yeah. That was a part of an hourly plan, correct?
Yeah, I mean, yes, it's the billable retainer. It's the only written agreement that we ever executed between us.
And
yeah.
She paid that $10,000?
She paid the engagement retainer, yes.
Okay, and then there was, you spoke about a $25,000 fee. That fee, did she pay it?
The flat fee right after
25,000.
at the pretrial conference for the trial, yes.
And that was a flat fee, and there's no written agreement with that?
We did not enter into, the retainer agreement stood. This was just, she did not want to go over a certain amount in fees. She was afraid of incurring 50, 75, 80, I mean, she was afraid of getting billed on an hourly basis. If you read my paragraph 3 of the retainer agreement, I mean, it states that should additional legal services be required beyond what is outlined in this retainer or what was discussed, additional fees will be required. We will keep you apprised of any situation we may feel that may cause you to accrue more legal fees outside of what is outlined here. So, you know, we discussed this, and, you know, she was, I think it would be not in dispute that at all times from the date that she hired me to the date of the trial, she was in financial distress and was concerned about it. And she was borrowing those funds to pay her legal fees. So I offered that, and those payments, to my knowledge, came for the trial fee, came directly from Ed. And then at some point, you know, they continue to add on, you know, again, without getting into the attorney-client privilege of the reasons that trial was delayed, you know, by request of Ms. Gonzalez. So essentially, you know, I was asked to continue to do work and prepare for trial, not asked, demanded of, and they didn't want to pay.
I understand, and I'm really trying to focus in on, and if I'm repeating myself, I apologize, but the initial 10,000 is part of a retainer agreement. It goes into the client trust fund account. It's in the amount of 10,000. At some point, you take that money out, put it into your business operating account, correct?
Yes, I mean, I'm telling you based on what I do on every single case. So
on this case,
you know, I'd have to go back to look on what date did I deposit it into my trust, but this is a non-refundable engagement retainer on which then I bill. And yes, I mean, the
okay.
agreement.
And did you take that money from your operating account and put it into your trust account before you sent her any billing statements, any itemized billing statements?
Did I take it out of my operating and put it in?
Did you take it out of its client trust account and put it into your operating account, your business operating account, before you generated any itemized billing statements?
I can't tell you on the date that I made any transfers.
Okay, and as far as that $25,000 payment, that would have went directly into your operating account because that's a flat fee?
You know, that's a good question. I have to tell, as a matter of course, I put everything into trust just as a tool of making sure that I'm keeping everything tracked. So I would imagine so, but in this case, there was not a separate flat fee retainer agreement. So I cannot tell you as I sit here for sure if I deposited the 25 into trust or if I deposited into an operating account. I cannot tell you.
And so then, is it fair to say if you did it, you wouldn't know when you did it?
Would I know the date of the deposit? No, sir. I wouldn't know the date of the deposit. No. Okay.
And when I refer back to your exhibit number 4, tell me if it's fair to say that this is are you speaking here about converting her from a flat fee back to an hourly rate?
My exhibit 4. On the notice of purging lien?
Your exhibit 4, the Ray says need to answer and counsel these questions at the top. Do you see that? So is part of the substance of that that you are talking about the possibility of taking her off a flat fee and converting her to hourly billing?
The flat fee agreement, the flat fee agreement was only for that period of time for the trial that was already set. That is it. So the only other retainer agreement that we have ever had between my firm and Ms. Gonzalez is the retainer agreement that she signed. That's it. The temporary pausing of not billing her was just a courtesy between her and myself. That was it.
Okay, I'm going to read it. I read this before, but I'm going to focus on this one sentence, and you can explain if this is consistent with what you're telling me. We did not bill you hourly to save you billable time and costs, as your case was set for trial when you first hired me. Okay, so was that statement true at the time you made it?
That I did not bill her hourly because the case was set for trial? That is a true statement.
And then, is it true that about a month later, you went back and billed her hourly from the beginning of your work?
I billed her for everything that was done at the request of Ms. Gonzalez to see the itemized statement of the work that was done that totaled $35,000 at that point. So I sent her, based upon her request, exhibit number, which we've already we've already discussed, but
I believe it's exhibit 6.
no, her email outright.
Oh,
Her email in which she inquired about wanting an invoice. She wanted an itemized invoice showing how $35,000 had already been expended. So despite the fact that that trial was continued, Ms. Gonzalez did not want to pay anything further after that point. So we had discussed many different options at that stage. Withdrawal being one of them.
okay. And so, and I guess what I'm having trouble with is just understanding, this started off as an hourly. It seems like it went to a flat fee and then back to an hourly, and she might have paid a flat fee that also that was also billed for her in an hourly time fashion, retroactively, it looks like. Is that not fair?
She paid a trial fee for a time period in which there was a trial set and then continued that trial.
When did you first ask her for the $25,000?
I can't tell you the exact date.
When you asked her for that $25,000, did you tell her, was it for a trial fee and that we would continue billing you hourly?
And I didn't ask her, sir. I didn't ask her for the $25,000. We had a very lengthy discussion with me outlining what it was going to take for our trial preparations and the billing that she could see or should anticipate leading up to that trial. We had a discussion and in which they then asked what I could do for them financially. So this is what we came up with collectively. And I offered the $25,000 for the preparations leading up to that trial that was already set.
Was it including the trial or was it only for preparation?
It was including that one day of trial.
And is there anything in writing saying what that $25,000 covers?
I think that even in your emails, she references the trial. So, I mean, it's there in your email exhibits. She says, I thought this was for the trial. I thought this was for the trial. And we continued to point her back to, yes, it was for the trial that was already set. But again, like I said, I did not engage into a separate or amended retainer agreement. And when I change my retainer agreements, or if some aspect of the retainer changes, we amend it. such that the former retainer agreement would no longer stand, and there is a clear retainer agreement between the client and my firm.
I just want to make sure my client's not getting double billed, because it looks like there's this $25,000 payment that's agreed upon, and I'm not sure, I still can't tell. Is that in addition, are you still billing her for everything you do hourly, and this $25,000's on top of that?
So I provided a final billing statement to Ms. Gonzalez upon her request that showed all of the work that was done. When you apply her $25,000 that she paid, there was still an excess of $25,000 that was incurred. So she's not getting double billed. I applied her payments.
But it's fair to say you only started doing the hourly billing months and months into the representation.
I don't know how, when you say you only started doing the hourly billing, the statement.
What's the date of the first invoice that you generated?
That I'd have to go into my case to tell you. I mean, when you say generated an invoice, again, if I printed it out today.
I can remember in the email that's sitting in front of me here, the one that's your exhibit 4, it says that you hadn't done any invoice generating as of January 2020, and you were initially retained back in June 2019.
We didn't hourly bill her, correct, based upon the agreement that we had.
And there's nothing in writing, right? There's no agreement in writing.
Well, I mean, she references it. I mean, there's not a signed agreement by either side, no, but we both reference that. Do you consider that an amendment to the original retainer agreement? To apply to the first trial. That's why I've included it as an exhibit.
Let
me put it this way, if we had gone forward on that trial date, on that 1-day trial that was set by Judge McGowan, there would not have been anything else billed. Now, she would have still had to pay her court reporter fees, which she also has refused to pay. But there would not have been anything else billed, and I would have honored that. She asked for that trial to be continued. She asked for more work to be done beyond what we discussed. And, you know, obviously the rules that bind me, I can't produce 575 emails to show all of the excess, what she and her boyfriend continued to pile on.
And I'm not asking you to get into that, but really, my next question is, is it part of your custom and practice to amend retainer agreements not in writing?
This amendment was an agreement as a courtesy, which, let me tell you, I won't ever do again. I won't offer something like this as a courtesy to a person because she took advantage. But to your question, when we actually do a substantive amendment that is going to apply for the duration of the case, I write a new retainer agreement and the client signs the new retainer agreement. In this instance, it was purely a sympathetic act on my part where I agreed to accept that amount to go to that trial. And let me tell you, it was her boyfriend who negotiated that entire, the amount and the terms of it. So.
And could you tell me what the total amount of fees that you charged this client? Not what she paid you, not what she owes you, the total amount.
That's reflected on my billing statement. What's charged on my billing statement and on the attorney's fees affidavit.
Okay, so maybe we can turn to the attorney's fee affidavit.
$53,675.80 were the fees incurred to the date of the filing of that fee affidavit. $53,675.80.
Okay, And so when it says summary of total costs, there's another number, 86,276. What is the difference between those two numbers? What, I'm sorry, that's not a good
Can I
question.
have
What
one
do you
second?
subtract? Go ahead.
No. Can I have just 1 second?
Sure.
The person running the CLE is texting me. I'm going to tell them that I
Okay. I'm going to withdraw
second.
that
I'm just
question
gonna-
and ask it in a different way.
Okay, sorry. I just had to text the. Go ahead. I didn't even hear the question. You can ask
I'm
me
gonna.
again.
I asked it in an inartful way, so I'm gonna clean it up.
Okay.
On the, I believe it's the second page of your fee affidavit, which is Exhibit 5 on your list. There's in bold, it says fees incurred to date, and there's a number 53,675.80. And then when I go down at the bottom, there's a similar heading, and it says total fees and costs paid, incurred, owed, and anticipated, and it's 86,276.60 cents. And I just see a big difference in those numbers. And can you just kind of walk us through how we get to that 86,276 for total fees generated by my client? Because I'm sure the husband's attorney is going to want to know.
Yeah, so let me see. Okay, so if we start with, well, first, there is a typographical error. If you look at the 25,275, that's supposed to be 25,075.80, which is not significant, but that is a typo. So the 53,000 in fees incurred to date would have been the total, I think, if I'm doing my math, of the fees that were owed up to the date that this fee affidavit was signed and what was paid, if my math is correct.
Okay, so it looks like you anticipated 7,000 more in fees, but when I add those numbers together, I only get 60,675. How do you come up with 86,000?
Hold on.
And change?
Let me see. Hold on.
And you
I
may
might have added. Sorry, I can tell you, and I don't think we delineated it. I think this was encompassing also, and we did discuss this, Ms. Gonzalez and I. This was encompassing her fees that she, and it shouldn't have been on our affidavit, but I think total fees that she's paid in total also encompass the fees that she had previously paid, not me.
So it looks like you're including in your total fees and costs the true total fees and costs, and then saying she owes money or there's some other money added in. It doesn't add up.
She only owes like what I represented in my opening. As of today, she owes what was represented that she owed my firm $25,075.80 plus the $7,000 that was incurred, for a total of $35,075.80 is what she owes my firm.
I totally understand that, but the total, not the total owed, because she paid some, she owed you some. What's the total? What's
$35,000. She owes still court reporter and.
That's not what I'm asking. I'm asking that what's the total price? Forget about what she owes.
$34,075.
How much? I'm sorry.
$34,075.80. And I mean, you and I have discussed this amount as well.
No, I'm not saying the total amount that she has a balance due and owes you money. What I'm saying is, if you look at this case and said, how much money did we bill out? Not what we collected. What did we bill out on this case? And at the top, it says 53,675. That's a total amount of fees incurred to date. Then I see another number it's $33,500 more.
In order to look at what my firm billed, it's better let's turn to my fee, my statement, my itemized statement. So if we
Use
look
whatever you need to explain how this math works. I just don't see that it works.
Okay, well, I don't think that that math, if there's an error on that total fees, costs paid, incurred, owed, and anticipated, that's not what I'm seeking, but it could have been what I believe is an additional amount that included fees that she paid to her former counsel. The total.
I understand. What I'm really looking at is I need to see what we're getting from what we need to claim for the other attorney to the husband to pay, and I can't see what your charges
Well,
are.
I don't know. I haven't seen a fee affidavit from her, but I do have invoices that Ms. Gonzalez had provided me from her former counsel.
No, I have that. I'm just worried about what is your total fee number.
Let's look at my fee, my statement, my itemized statement.
And would everything be on the itemized statement, or would there be like an extra 25,000 in flat fee that's not included and we'd have to add that on?
Everything is included on my itemized statement, but for the prospective fees that are outlined on my fee affidavit that were incurred with me representing Ms. Gonzalez during the final hearing. Do you have it in front of you?
Which document are you speaking of? Your itemized billing?
Yes. I don't know if you're waiting for me or if you were just reviewing that, because there's a total.
I thought you were looking at it to get information to answer the question, and it's been a little while, but and let me just ask it again in a different way. Is that the way I see your affidavit? I see that you had incurred $53,675.80 in fees actually incurred at the date of this, and you anticipated 7,000 more. So when I add it up, I get $60,675.80 should be the total, not $86,276.
I think you're probably correct as to the fees incurred by my firm, although there's also a difference. If you look at my statement, and that statement was attached previous to the completion, I think, of this fee affidavit, but it's $47,075.80. When you ask me the question, the total amount billed only by my firm, that balance would be $47,075.80. So, and that's according to my my fee statement, which has not been. So when you say generating invoices, I didn't continue to update these invoices after the final one was sent to Ms. Gonzalez. So nothing else was added, nothing else was updated thereafter.
Okay, so would you be able to tell me, after reviewing everything, could you give me a hard and fast number of everything, the total amount that your firm billed for representation costs to my client?
The total amount billed, $47,075.80. And I'm going with my number on my itemized statement that reflects everything that was done in this.
Okay. And I'm just not sure how to reconcile that number with the numbers on the affidavit, do you see that your attorney affidavit is consistent with the information you're telling us, or is it inconsistent?
I see that the current owed is correct and consistent, other than that the typographical error. This 2 that should be a 0. The 25,075.80 is an accurate figure.
Okay, I understand that. What about the other figures?
I can't tell you. I have a recollection of.
I just want to make a point, because the point being is, that would be a balance, and you would only have a correct balance if the total was correct. And also you knew how much she paid, and that number was correct.
Her payment was $35,000. She did not pay anything in addition to $35,000.
So that's clear, 35,000 paid. Now, the other piece of the equation is, how much is the total bill? We're subtracting 35,000 from what to get to 26, but 25,075 owed.
The 25,075.80, which is reflected on my statement, plus the $7,000 prospective that was outlined on the fee affidavit that was incurred as a result of the trial representations.
So when you put the 7,000, is that included in the 25,000 owed, or is that actually 32,000?
It shows they're separated. Current owed to date, 25,075.80. Fees anticipated, 7,000.
Okay, so correct me if I'm wrong, but I think the math works out if we add things up incorrectly. I think you have a total fee of $53,675 at the time this affidavit's written. Then she currently owes $25,000. If I add that, which we shouldn't, but if I add that, it comes out to about $87,000 and change, and then I add the 7,000 more, and now I'm getting your 86,000 number, but it's wrong accounting.
Okay, the 86,000 is not, I'm in agreement that there is some error in the 86,000. I am looking at, so if we don't look at the total fees and costs paid, incurred, owed, and anticipated, that line, total fees, cost, although it could be the cost added, did you add the cost in? So we can take out the calculator. It says and costs, owed and anticipated. The only figure that I am looking at that I believe are pertinent for today are the fees that were owed to date, the fees that were paid by Ms. Gonzalez, and the incurred fees for the trial representation. There is no dispute in those numbers.
I'm still, it looks like you're counting that 25,000 for what's owed into the total. The total of what you bill is completely different than from the amount you're owed. And you're counting that as an amount owed.
I'm not understanding what you mean by that. The 25,000 is the amount owed.
Okay. You're right. I said that wrong, but.
Okay, maybe I don't understand then.
What I'm saying is you charged her a total of $53,675 at the time, right? She had a balance of $25,000, but that's separate. How do you figure that balance, that what she owes you? You're counting that again, saying here's the total, your number, total fees, costs paid, incurred, and owed, and anticipated. It's confusing.
I'm not counting it again. I'm asking this court to award the $25,075.80.
I understand, but we have another issue, and we need to know. I can't go to the other side and say you owe us 50% of a reasonable attorney fee when I don't know what your fee was.
My fee is outlined in the statement. My fee is outlined in the itemized statement, and my fees owed to date are clearly reflected on that. The $25,075.80 plus the days of representation. At that point, they were not yet earned, but they were clearly earned. So I'm not sure.
Is it fair to say that the total cost of the representation was $53,675.80 plus the 7,000 anticipated, and that's it? 60,000?
1,000 anticipated.
7,000, so, okay. So it's 60,675.8 is the total fee. Correct?
Inclusive costs, yes.
Okay, thank you. I don't have any further questions.
Okay. Mr. Shutt, you have questions?
Yes, my first question is, Ms. Sparkman, do you have an expert available today to testify on the attorney's fees?
On the reasonableness, no. I need one, but I mean, by rule.
It's not necessary under the family law rules. The court is allowed to rely on the affidavit.
Yes.
I was just looking at one of the cases, Your Honor, a family law case, Caso versus Caso, and another one, Saucy versus Saucy. But if the court's wanting to proceed, that's fine.
Yes, sir, I do want to proceed. Thank you.
Okay. And if I could look at what your Exhibit 6 is, if we can go through that.
You keep breaking in and out. I can hear some words, but I can't hear all of them, sir.
Okay, I want to, exhibits, do you have Exhibit 6 in front of you?
The redacted invoice, I mean, I have it. If you
Okay.
could share the screen, or if I could, it would help.
Okay, let me see if I can do that.
Your Honor, can you give I don't know if you have to give the controls to share.
I thought my computer allowed for share screen, but let me look.
It's allowable. It's
Oh,
not-
okay. Thanks, Tommy.
You're welcome.
Yeah, I never turn off the screen share. I let people share. If I do, it's by mistake.
Okay, let me get to that.
Or even just tell us what page you're looking at, Mr. Shutt, because I think we all have a paper copy of these exhibits.
Yeah, I might be able to bring it up real quick here.
Okay,
Let me see if I can do that first.
great.
And can you see that?
Yes.
Yes, I can. That's
Okay.
perfect. Thank you.
And okay, and this is the basis, your detail of the attorney's fees, is that correct?
This is the statement, yes.
Okay. So as we go down,
Okay.
look at page 1. The first
Yes.
entry you have is for legal service, $140.4.
Yes.
Okay. And it says email to client with a retainer agreement and attachment scanned. Is it your position that is not a clerical task performed by you where it's scanned, printed, saved, and copied to digital?
I mean, it could be clerical, absolutely. I mean, I'm not disputing that it couldn't have been.
And what is your understanding of what is permitted as a reasonable attorney's fees with regard to an attorney performing clerical duties?
Oh my gosh, I have not been asked that question. I would be feigning if I said that I can tell you specifically what everything is that's included. I'm going to leave it to the court's deference.
Okay. And Judge, I would like to address that standard after we do the questioning, because I have case law I provided prior to the hearing to opposing counsel.
I'm aware of the standard, sir.
Okay,
I don't
thank you.
know if any of you guys knew this, but I was a practicing family attorney for 25 years prior to taking the bench. I know you guys probably are aware that I mostly sit in criminal court, but I was a practicing family attorney. So I'm pretty familiar with most of the case law, maybe not the most recent case law, but I've done several fee hearings and I think I'm aware of the difference.
And I will say, Mr. Shute, is it Shute? I don't
Shoot,
want to.
that's correct.
Okay. If your question was specifically on that, I can't tell you. On a general basis, of course, I know that, there's certain things that are just not going to be awarded in terms of reasonableness. I'm perfectly, I have no, I mean, a lot of this we could probably even stipulate to. I'm not disputing that there's certain things that are going to be either reduced or stricken if the court feels that it needs to be. Okay.
Well, then let me ask it a different way. If we can look at page 1
Okay.
of what is Exhibit 6, can you tell me what on this page 1 you do not consider to be clerical work, but instead actual legal work?
Of the highlights,
Of anything on there? What would be purely legal
Well, these-
work? For example, I would argue that putting something in a digital file is clerical.
but there are other things that are done within that entry. So, and this is billed at a mere $100 an hour. I mean, this is hard copy of clients' correspondence, multiple emails, draft emergency motion on behalf of client, draft of proposed order is not clerical, particularly not in this case, draft of emergency motion to continue hearing and sent to SNS, which is done again at $100 an hour, SNS being me for review and edits. That's not clerical. E-file and e-serve, wife's emergency motion, multiple phone calls to client and JA Crystal in regards to case. That's not clerical. And, you know, just to note, I mean, the specificity of the time that's expended is also on some of these entries, 3:15 and 3:18. So 2 phone calls. So other than the first one, the retainer agreement that was drafted by me and sent, which I think it could be reduced to 100 according to the law, but that is clerical. Doesn't look like anything substantive, other than perhaps what my initial email might have stated. Everything else to me is substantive work.
Okay, so who is IF under the entry?
My paralegal.
Okay, are you aware of what statute 57.104 provides? Of attorney's fees based on paralegal work?
You'll have to tell me specifically. I mean, you can read it.
Okay, so when it says create a full file and open digital file, is that non-clerical work or clerical work?
I'm not disputing that first entry.
No, I'm talking about the second entry, which is the first entry for IF. I guess we're going to have to go through these one by one, because to me they're clerical. If I give it to my assistant, it's clerical, but you're not answering the question. Is creating a full open digital file clerical work or legal work?
Line item 2, yes, I think that's clerical. The line item 2.
Number 3, update of digital file and hard copy file with clients' correspondence, multiple emails. Is that clerical work or legal work?
Legal. I went through all those. I mean, we can certainly take the time to do that, but I went through all of those. I do find all of the ones that you've highlighted to be substantive.
No, you gave me a gloss over. You didn't answer and give me specifics. So going back, I'm going to ask you again. Update of digital file and hard copy file with the client's correspondence, multiple emails. Is that clerical or legal work?
Legal.
So updating a digital file and hard copy you believe to be legal work?
That entry is legal.
Okay. Draft emergency motion on behalf of clients. What was the outcome of that hearing?
I couldn't tell you.
Draft of proposed order granting substitution of counsel and send to SNS for approval. How much of that was actual drafting versus actual sending it, emailing it, or however it went to the other side?
I couldn't tell you.
Next one, correspondence. Doesn't say anything. How do we know whether that was clerical or illegal?
I mean, I couldn't tell you, but I mean, you know, this is a pretty extensive billing statement. And if you're, you know, I'll tell you right now that aside from maybe, you know, a few entries here or there where I would be able to tell you specifically, if you're going to ask me line by line, I probably already know what my answers are going to be.
Well, that's fine, because you're today asking for $40,000 or $30,000 or $50,000. I don't know. I would expect that if you're asking for $40,000, you would know exactly what you're looking for. Going to the next one.
I've been
Draft of emergency motion.
I've been looking.
Is this the same one?
If I may.
Or is it a double entry? It's on the same day, May 1st.
If I may speak, this has been before the court and filed with the court, this statement, since last year. So, I mean, I certainly could have been deposed on it so that I could have brought the copies of every single emergency motion and every single draft, along with the outcomes of every single emergency motion. But today, as I'm sitting here, if you're asking me for specifics on each line item, I'm not going to be able to tell you, and that is not because I'm trying to be evasive or not give you the answers.
Well, this is the second time this matter was set by the court for hearing. We're here today on the second time, and a deposition is nice to provide me information, but you're here asking the court to award you a sum of money, and I'm not getting real answers. Going back to those two line items on May 1st, draft of emergency motion, are they the same or different? And I'm sorry, I'm not looking. Is it the same one as on 429?
I couldn't tell you. I can't tell you on any of these with specificity. So I'm just telling you again, right now, I cannot tell you other than what's contained within each of those entries.
Well, the last one, e-filing and e-serving a verified emergency motion and telephone calls with the JA. That's clerical work, correct?
Multiple phone calls to the client in JA. I would appreciate you not leaving out things and reading the entirety of what that entry is.
Okay, so that's clerical work, correct?
No.
Performed by the paralegal.
If you believe that phone calls to a client in a family law case is clerical, then you and I have a completely different interpretation of what zealous representation is.
Is your paralegal providing legal advice to the client during these phone calls? Or is she simply scheduling the matter?
You don't have to provide legal advice in order to be doing a paralegal service.
No, but to get attorney's fees for that, under 57104, they have to provide non-clerical, meaningful legal support to the matter involved and who are working under the supervision of an attorney. So scheduling a hearing is not meaningful legal support.
That is not scheduling a hearing, sir. You are misrepresenting my statement, and I don't appreciate that. It clearly states multiple phone calls to client and JA in regards to the case. How are you going to sit here today and claim that that was not meaningful legal support?
So when the paralegal talks to the client on the telephone, they're providing legal information and support to the client? Is your paralegal available to testify today?
Did you subpoena her to testify today?
No, it's not my hearing. I'm not the one seeking money. You're like a plaintiff. You have to produce your evidence under Florida law, under the case law. It's your obligation to present your case, not mine to prove a negative.
You are direct examining me on this, and you are attempting to show that these entries are not reasonable. So I would disagree and say that it is actually your burden to have brought in whatever witness you wanted to show, for whatever reason, that you believe that my entries are not substantive. My burden has been met.
Well, Ms. Sparkman, there is a case out there, Coriat versus Coriat, 2020 Westlaw 6302420 out of the 3rd District. Is so new, it doesn't even have a citation to it. And it says, and I quote, that the court must determine the portion attributable to clerical and secretarial work. And that work is specifically to be excluded from taxable costs. So it is important that we determine what portion of your billing is clerical.
I agree. And I don't know that case, but I do know that in previous hearings, multiple, I'm sure Your Honor has done the same, that inquiry is made. But I'm answering the question. And if Mr. Shute wants to attempt to impeach what I'm saying, I mean, it's not my obligation then to have the paralegal sitting right here. I've stated, and I think my billing statements are pretty detailed, but for counsel to say that that's not meaningful, or to try and shift it to make it sound like that entry was something other than what it was, is I mean, I said in the very beginning, the court's going to make a determination. I will respond to each entry as I have knowledge of it as I sit here today. But I mean, I stand by what's in all of those entries.
And that's your position, Ms. Sparkman, and his position may be contrary to that. And that's why I'm hearing this case today. So, he's entitled to make the argument that it's clerical, and you're entitled to dispute that and take a position contrary to it. And then the court obviously has to be the referee. So you can continue, Mr. Shutt, please.
Thank you. Going to page 2, top 2 entries, you have between you and your paralegal over 11 hours prepping for a hearing. What hearing was that for?
I can't tell you. I mean, if it's 5/2/2019, it would be for whatever hearing that was close to that date.
And what was the outcome?
I can't tell you what the outcome was, sir. I'm sorry.
Was that a pre-trial conference that you were preparing for? There was entry on 5/3?
It could be.
Okay. So you and your paralegal spent 11 hours preparing for a pre-trial conference?
Well, it says, sir, again, I know you like to read part of things, but it says attendance for hearing, PTC, and other motions, Collier County, preparation for hearing and travel time, courtesy waiver of all mileage and gas cost incurred. So,
right, but you've already testified you don't even know what motions they are, so I didn't bother to ask.
well, there were motions. So if you wanted to question me on them, you've highlighted this, so you clearly knew what you were going to ask me on. But I specified in this entry that there was a PTC and other motions.
Do you know what the Florida standard is on awarding attorney's fees on motions when you're not successful?
I am not sure, as I sit here today, what the outcome of those motions were, or what the substance of those motions were. So I'm not sure where you're going.
Going back to that entry, what was your travel time on that day?
I don't know.
Do you know what the Florida standard is for reasonable attorney's fees and awarding travel time?
I don't know off the top, but it looks like we waived it. I know it says courtesy waiver of all mileage and gas, but I think we waived it. I would not have charged. I'm not sure. I can't remember what we did on that day. I'm sorry.
You don't have any breakdown of travel time versus actual in-court time available to you today as we testify?
No, I don't. I just know that we waived something, and I remember Ms. Gonzalez and I having a discussion that I wouldn't charge her for the gas or the mileage or something of that nature.
May 6th, correspondence, 3.6 hours. No detail of what that's for. But it's $1,260. We don't know what it's for. Do you know what it's for?
That's very odd. That's completely empty. No, sir. I mean, it's empty, so I'd have to go back. I just made a note of that.
Here's some phone calls and correspondence. Would you agree with me that's clerical work?
No, not when we've specified that it's in regards to depositions, opposing counsel regarding depositions, maybe the scheduling the phone call portion of that, but the remainder regarding the depositions, I would say is substantive and legal.
So your paralegal is discussing substantive legal issues with opposing counsel under your supervision? Is that your testimony?
She's providing legal support as she is allowed to do.
And as far as it goes, it says scheduling phone conference.
I already said, sir, that the portion of that entry that says scheduling phone conference, I would agree is clerical. The remainder of it, it is my position that it is substantive and legal.
Okay, so what was this call on 5/7? It took 12 minutes, I'm assuming is. What was the context that made that a non-clerical call?
I wouldn't know. We had substantive phone calls with Ms. Gonzalez almost every day, multiple times a day.
Well, I'm talking about opposing counsel. Phone call to opposing counsel. I mean, you're asking for attorney's fees. I don't know what she was calling about.
What would be well, it's there. I mean, it's there that there was a phone call that occurred.
Okay, but as we sit here today and you're asking for all this money, you don't know what that is.
I don't know what the specifics are. I know that what the entry states is what occurred and the work that was done that should be paid.
Okay. And then we have 7 emails from clients and with attachments and forwards and copies to her former counsel, Denise Gunn, commencing 4:36 to 7:38. So you were doing constant emails for approximately 3 hours with the client on the one day?
Yes, sir, I was.
Phone call with JA with 1.8 hours. You spent almost 2 hours, or I'm sorry, your paralegal spent almost 2 hours on the phone with the JA?
If that's what she put, that's what she did. Like I said, this case was never non-complex, simple or easy.
Well, what legal matters was your assistant discussing with the judicial assistant for almost 2 hours?
I can't tell you what occurred on that date. I know that if she entered that there was a call that was made with the judicial assistant. That was work that was done that was taken away from other client files.
Do you know if she was on hold during that time?
I don't think
working on other things?
I don't think she would be on hold for 1.8 hour or 1.8 of the time frame that she put in. I can't tell you exactly what it was for, but it looks like there was another hearing coming up, so I'm sure it was regarding a hearing.
These 9 emails throughout the day, do you know what they were in reference to? Were they in reference to scheduling, or were they in reference to specific legal matters?
Well, it's with the client. And like I said, I represented earlier today, there's 575 emails from Ms. Gonzalez between her, my staff, and myself. So that's probably just one set of those that total the 575.
So would it be fair to say that Ms. Gonzalez was acting excessively with regard to email communications with your office?
I wouldn't characterize it as excessively, considering where the case posture was for her at that time.
But then you spent roughly half your day that day just responding and dealing with her emails. Is that correct?
There was a period of time that I spent nearly almost every day working on her file.
And on 5/11, what was that about? Do you know? Do you know who it went to?
These look like they are redacted, and your redactions are not showing up now that I'm thinking about it. They're not showing up on the Adobe. So if there was something substantive, regarding attorney-client privilege, this is a redacted copy that you are looking at.
I didn't redact it. This was pulled off the court file from
that's not
March
what I
2nd.
said, sir. That's not what I said, sir. We
One at a
redacted.
time, please. Everybody
We
one at a time.
redacted.
First of all, we're over Zoom, which makes it difficult. And second of all, we have a court reporter. So when you guys talk over each other, she can't take that down either.
Sorry, Your Honor, and I'd like to go back. So now that note that I made for the 5-6 entry that you showed me, that was the correspondence where we specified certain information that Ms. Gonzalez provided to our office. I would have directed my staff to redact that specificity of the correspondence. So that is with the client. Any of those blanks are redactions.
So neither I, anybody else, the court know how 3.6 hours got billed that day, correct?
Well,
we don't know what that was for.
Those are with the client, communications with the client.
But we don't know that. It doesn't say that.
Well, the only way to know that is if they were entered and the attorney-client privilege would be violated, which I'm not going to do. I don't even think I'm allowed to provide those in camera to the court. I mean, the invoices have to be redacted.
I think they can be provided in camera to the court if your former client agrees. And if Ms. Gonzalez agrees to allow the non-redacted correspondent or billing statements to come to the court, then I think I can review them in camera.
I would be happy to provide them if she agrees to waive it. We have a complete unredacted copy that has direct information from Ms. Gonzalez. So I'll be happy to do that if we get it on the record that she waives attorney-client privilege as it relates to the entirety of the billing statement, no matter the subject matter that might be conveyed in those entries.
Mr. Stein, you want to discuss that with Ms. Gonzalez to see whether?
I'm sending her a text. I may need to speak to her.
Okay. Well, you know what? Right now would be a good time to take just about a 10-minute break anyway, because we've been going for about an hour and a half. And I just need to check in really quick with my judicial assistant because I have a bunch of stuff scheduled in the morning. I want to just make sure I've got all my stuff ready for that because she leaves at 4. So let's break until about, it's like 8 after. How about 20 after? And we'll come back. And then that'll give you a chance, Mr. Stein, to speak with your client about the issue of whether she'll agree to allow the non-redacted billings to be submitted to the court in camera.
Thank you.
Will do.
Okay, thank you. I'll be right back. I'm back a little bit early. All the clocks in the courthouse have different times, so mine was a little fast. How we doing? I think we're missing Miss Gonzalez and Mr. Stein, so we'll wait a minute for them to be
I'm
ready.
here. Miss Gonzalez will be on in 1 second. We just got off the phone.
Okay.
What I can tell you is she will waive, and we can confirm that if you need to.
Sure, let's just get it confirmed on the record. Hi, Miss Gonzalez. Hi. So are you okay with the court reviewing the non-redacted, or are you saying that you would agree that the non-redacted could be used in this hearing? What's your preference?
Absolutely, and open for her to review whatever she needs.
Okay. Is your understanding, Mr. Stein, that I will be reviewing it in camera, or that we're going to utilize the non-redacted records in this hearing as well, or where are we going with this? Just trying to understand.
I need to see it. So, however, if you review it in camera, I need to see it.
Okay. Well, then I would think that it should also be provided, Ms. Sparkman, to Mr. Stein. And if it's provided to Mr. Stein, then obviously it needs to be provided to Mr. Shutt as well. So I kind of think, Ms. Gonzalez, that if you are going to, if you're going to waive the right to, have the record redacted, it might make sense in order to have a full record. It doesn't sound to me like you're objecting to the things that are in your billing record that your counsel did for you, that you may want to just simply allow all of it in. I mean, your case is already over, but that's up to you. The attorney-client privilege attaches even after your attorney-client relationship is over. So you have the right to maintain that attorney-client privilege, but you also have the right to waive it.
Your Honor, we had a discussion about this, and she's curious as I am to see what's in there.
I see. Okay.
She has the unredacted copies. I redacted them for court. She did not receive so for example, if we just look at the 5/6/2019, the one that was empty, that block, that itemized entry that was empty, if Miss Gonzalez pulls the original email that we sent to her attaching the acted, and she will see that there are entries that are very specific as to things regarding Miss Gonzalez.
Discussions about her case?
Discussions about her case, yes, and certain specifics related to her now former husband. So I am leery without Miss Gonzalez clearly stating that she's waiving attorney-client privilege.
If I can jump in, maybe Ms. Sparkman can send it to me, and because I don't think there's any issue with that, or she could send it to my client unredacted. My client apparently doesn't have an unredacted version handy.
Okay.
And then we can look at it and then make an informed decision.
Okay, that works for me. If you want to do that, Ms. Sparkman, I don't know if you have the ability to do that.
I do.
Now, or you could just email the unredacted one to Mr. Stein. So when there's a moment during this hearing, he could take a look at it for 5 minutes. I mean, there don't seem to be a significant amount of redactions that it would take, an hour to do, but at least you could take a look at, the 5/119, there's correspondence redacted. There's 5/6/19 correspondence redacted, 5/7/19 case progress redacted, 5/11/19 correspondence, some of it's redacted. I mean, you can see on these billings where the large chunks are, where there's redactions, and I think it'd be easy enough to just take a look at it and see whether the redactions are something that are significant that you want to keep redacted. But
Is it bob@bobsteinlaw.com?
Yes.
Okay, it's being sent now, and I've also copied Miss Gonzalez. Is your email still divorce.juliet@yahoo.com?
Yes.
Okay, I've sent it to both of them.
all right, fantastic. Okay, Mr. Shutt, you want to proceed, please?
Yes, you can just give me a minute, Your Honor.
Sure.
Looking at this entry on 5/23/2019 for 2.3 hours. Do you know what those, why those calls to the JA and opposing counsel took so long?
I don't, but it wasn't just the calls. If you read the entirety, there are other items that were accomplished during that 2.3 hours.
Okay, so pulling a pretrial order, which I guess is getting it offline, or reviewing it, and then pull a motion for contempt, which I guess is either pulling it out of the file or getting it offline, correct? Or is there something else I'm missing?
I'm not sure. I mean, obviously these statements are in summary form. So pulling April motion for contempt, I'm not sure, you know, where it was pulled from. It could have been pulled from my case. It could have been pulled from the digital file. It could have been pulled from the docket. It could have been pulled from the link that the opposing counsel sent us. I'm not sure.
Well, this kind of goes to every entry you've submitted. How do we know 2.3 hours is reasonable to make a couple phone calls and pull a couple documents?
I'm getting background noise, but I think what you said is, how do we know that a couple phone calls is reasonable?
No, not the calls are reasonable. 2.3 hours to make 2 phone calls and pull a couple documents.
Well, I mean, we can always spin it to sound like, how can it be 2.3 hours to make a couple calls and pull? But again, if I were to spend 2.3 additional hours to make sure that my summary on my itemized statement is in detail form so that it supports the 2.3 hours, I'd be billing an additional 2.3 hours to spend that 2.3 hours to summarize the work that was done. So again, there were calls that were made. Do I know exactly how long each of those calls took? Typically, if there is a chunk of time that's spent on a case, they're grouped together like that. So I am pretty confident in the fact that these were not things that were spaced out during the day, and they were done in tandem with each other. So whether the motion for contempt was pulled or the pretrial was pulled and then the calls made, the time was the time, the 2.3 hours that was spent.
Mm-hmm. Okay, but we don't know how that time was spent as we sit here today in the hearing, correct?
Yes, we do, and I can repeat it again. There were calls to the judicial assistant, review of previous pretrial order, pulling the April motion for contempt, and calls to opposing counsel. So more than one call to opposing counsel, more than one call to the JA, and a review of 2 different pleadings.
Okay, so as opposed to writing down, calling the JA to set a hearing, she didn't do that. What was the call to the JA about, and how long did it last?
Well, I'm not
You're asking my client to pay these fees as well. So can you tell us, as we sit here today?
I'm not asking your client to pay the fees. The court awarded that. That's not my call to make. But
well, they're your fees. You have to support them. The court will order what you can provide support for. My question is, what was the call to the JA about? How long did it last? Or can we even find that out today?
If you wanted specifics as to what my paralegal had done, you could have subpoenaed her and she would have been here. However, what is stated in that entry is what was done. That was the work that was done, and that was what was billed to Ms. Gonzalez. I mean, I know you're here to rebut the reasonableness because your client was ordered to pay, but this is a charging lien against Ms. Gonzalez, not your client, just to make that clear.
We're just trying to determine what's reasonable, and it helps to know what it's about as opposed to that it was written. So we have more redactions.
Mr. Stein, as he's scrolling, did you receive that email?
I did, thank you.
You're welcome.
And in June 12th of 2019, spending just over an hour to review the judge's procedures and requirements to set a hearing and filing a notice of hearing in order to draft July 3rd notice of hearing. So was this your paralegal learning how to comply with the court's filing requirements for a hearing?
Learning is a good word. There was a lot of different procedures and protocols, and we needed to do it correctly per what the judicial assistant advised both myself at some point and my paralegal. So what I can tell you, there was some issue with this particular direction to my paralegal go on to read these requirements. I don't know if you happen to pull these requirements, but there was something that was substantive on that. I cannot remember with specificity what exactly it was, but she spent the 1.1 hours to do that in preparation of doing a notice of hearing.
And then the next entry is e-file and e-serve. Isn't that clerical work?
Yes, I mean, yes, you served that notice. Yes, it is.
And then we've got more work here. Looks like the same draft and file NOH, download, print, and review McGowan logistic procedures on filing, spending 2 hours for your paralegal to figure out how to file something, a notice of hearing again. So we got over 3 hours trying to file a notice of hearing. Is that what that says?
Well, so it's not again, and it's not trying to figure it out.
It's the same day.
We could probably go on and see what exactly those specific requirements were, but it's not as simple as she's been a paralegal for 4.5 years preceding this case, so it was not something as simple as a notice of hearing, but there was something specific and germane to that particular case or to that particular situation in motion or pleading. Can't tell you exactly what it was, but I do remember there being an issue and a situation related to the procedures and requirements for Judge McGowan.
And it took a paralegal with 4-year experience over 3 hours to get a notice of hearing filed.
4.5
That's your
experience.
Yeah. Oh, okay. So still took over 3 hours. File a notice of hearing.
That particular instance for that particular hearing, yes, it did.
And then we've got more redactions, view a digital file. Draft of GFL, good faith letter.
Yes, sir.
What happened on that motion to compel? Was it a granted or denied?
I cannot tell you, as I sit here today, I can't even tell you what the ultimate ruling was after a 3-day trial. I don't know what that hearing outcome was. I'm sorry.
And then following that, telephone calls to do a telephonic appearance and to confirm that. Is it your testimony as an attorney you don't consider that clerical work?
Tell me what line item. I just got a message on my computer saying my internet is unstable. So you cut out completely.
Okay. You have email to JA regards to telephonic appearance, email to judge office asking for electronic confirmance and send digital file. So is it your testimony? These are not clerical type tasks?
I think a portion of that would be, if you're referring to, you're moving the June 28th portion of that would be for sure. The June 28th on top of that one, yes, in regards to just asking about my telephonic appearance, again, that's pure scheduling. So yes, I would agree with you.
And then this entry, multiple emails from and to client in regards, do you know how many emails it was that day that your paralegal was dealing with Mrs. Gonzalez?
Sir, no, I don't. I mean, that looks like it's redacted. So hopefully we'll be able to resolve that issue and the court can see everything unredacted.
More redactions and email to the JA, that's clerical, correct?
To provide a courtesy copy of the notice of cancellation, perhaps so, yes.
sending it to the husband. That's
Sorry?
clerical. More emails, those would be clerical.
Email to husband. Yes, can we,
2 of them.
okay.
Here we have another 3.3 for emails, but I guess we'd have to look at the unredacted or redacted. Draft a motion to continue pretrial and final hearing. You know how that turned out?
Well, we know that we had a trial that was set, so it was probably continued.
No, was the motion granted or denied to your knowledge?
Well, it sounds like it was granted since we had new dates that were set.
But you don't know for sure?
I can't recall. I know I have the knowledge. I can't recall sitting here right now without reviewing every order that was entered in this case. I'm sorry.
Okay. Phone calls to private mediators. I guess that's setting up a mediator. Isn't that clerical work?
What is the date entry that you're looking at?
7/26. We got another one, clear mediation,
Hold on, can we
7/26.
pick one at a time? I'm assuming on the ones that I have said that I agree that it's clerical, that you're going to go back and find the dates for each of those so that we could then relay to the court which of those entries were agreed upon, and then you've kept a running tally of the ones that we haven't agreed upon, because some of these you're not even mentioning the dates.
Well, I'll mention them. It's 7/26. You have it, and then again on 7/26. I guess you're calling to follow up with the mediators, but you have a lot of phone calls. I mean, that type of stuff. Because wouldn't you agree that scheduling matters, whether it's deposition, mediation, court hearings, whatever, is clerical type work,
I've
and
already
not legal work directed to the case, resolving the case from a legal standpoint?
Counsel, I've said that from the very beginning before you started examining me, that I agree with you that there are certain work that is clearly in the domain of clerical, and phone calls purely regarding scheduling is one of them. So I agree with you on that. Yes.
So then the court can look at this then, and if they see it's a scheduling or whatever, or correspondence with the court to schedule something or reset something or whatever, you'll agree that's clerical work.
If that entry is exclusively on scheduling and other work was not performed, then yes, I do agree. I do agree that if there's an entry that only exclusively states upload to digital file, I agree that's clerical. I agree that if there's an entry that only states e-file and e-serve, that is clerical. Everything else, I do not agree is clerical.
And so when it's mixed together, one-time entry, how do we break that down?
Well, I think that the court can then, ascertain how much to prescribe to an e-file of a notice of hearing, usually a one-page document. So if it's a 1.8 entry and that entry contains multiple phone calls, multiple emails, responses, draft of a pleading, I think the court, as the court indicated, has done this long enough and is now on the bench that she can remove and is competent to remove the entry related to the clerical uploading or e-filing.
Okay, so it's not the attorney's job to make the detail of the bill for attorney's fees purposes. It's the court's job to glean from today's testimony what that could or should be.
No,
That's your testimony?
You're challenging the reasonableness of the fees that I've outlined. I have outlined with the specificity that I am upheld to outline the statement in. I mean, this is more specific than I've seen many statements. So,
well, I want to challenge the reasonableness of legal work. But these bills, from my perspective, as a lawyer practicing over 30 years, contains mostly clerical work. Court decides what's reasonable legal fees, whether it should take 4 hours to draft a motion for continuance or 1 hour, whether it should take 2 hours to draft a notice of hearing or 30 minutes or less. I'm trying to ferret out because it's all a mix mash of both clerical and legal with a lot of redaction. So it's very difficult for me to know exactly what you are saying is a reasonable legal fee when you haven't taken out, but you seem to want to mix clerical work with some unknown type of legal stuff.
Well, when you say unknown type of legal stuff, I mean, I mean, it's somewhat insulting because
No,
this is months and months of representation
But it's 2 hours here.
on a divorce proceeding, on a divorce proceeding in which there was a 3-day final trial. So I think you would agree that clearly to get a case ready for a 3-day final trial, that there is going to be some legal work done and not just clerical, sir.
How many depositions were taken?
I can't tell you for sure, but it would be on the statement.
All right, we'll see if we'll find one.
I don't know how looking for one deposition is going to your point, but this is your examination.
So received email from husband with motion to compel review. So it took you 1.2 hours to review the husband's pro se motion to compel?
Yes, it did.
Okay. How long were you practicing law at this time in 2019?
I don't know. You can look at my affidavit. Since 2005.
Okay. So after 14 years of practice reviewing a pro se motion to compel, you spent 1.2 hours? Is that your testimony today?
It is my testimony.
And your rate at that time was $350 an hour?
Yes. I don't know what your reviews in divorce cases encompass, but a review of a motion to compel in a case like this is not simply reading. So if you're suggesting that all I would do as a lawyer who zealously but a review of a motion to compel in a case like this is not simply reading. So if you're suggesting that all I would do as a lawyer who's zealously representing my client, as I do in all of my family law proceedings, would just mean reading, you're incorrect.
What does digital file mean? Does that mean you just save it to the hard drive?
No, we have a digital file for each specific client.
Yeah. And that's that would be clerical work, correct?
Again, yes, I've already said that I concede that if there's an upload to a digital file, if there is an e-file, if there is a scheduling entry exclusively, that those things are clerical. I agree with that.
We have a lot of redactions here. Multiple emails to mediator to confirm mediation. That would be clerical, correct?
Only if they were regarding scheduling. But, you know, the drafting, the notices of and the drafting of are not. The e-file and e-serve is clerical again. I can't hear you.
We can hear you.
Half hour.
I
Still can't hear you.
Okay.
Yeah, Mr. Shutt, you're kind of muted.
I still can't hear you.
3.9 hours.
Mr. Shutt, we can't hear you, sir. Nobody can hear you. I
Make
don't
sure.
know. There we go. There you are.
Okay, it might be the connection. And here it's redacted. We don't know what almost 4 hours was spent, but finalizing edits on a notice of mediation took a half hour. I mean, that you could write one, couldn't you, in a half hour?
Could I what?
Couldn't you write a notice of mediation in a half hour? Editing one that's already drafted took your assistant a half hour?
Yes. I mean, I don't know. Like, I'd love to steal your paralegal away.
And you can't have her. Multiple internal emails. Does that mean it's between you and your assistant?
Can you tell me the date again that you're looking at?
Sure. I'm sorry. I thought you might be able to see the little cursor. Like
No, I can't. Okay. Multiple internal emails. So that's November 20th, 2019 correspondence, emails in relation to correspondence to the court at 11:39, 11:41, 12:17, and 1:45. So, I mean, Yes, clearly this is regarding emails back and forth with the court directly, and each one is itemized with the time. So I'm not sure what your question is there.
Well, it says multiple internal emails in relation to correspondence with the court. I don't think it's with the court. I'm reading it as emails between you and your paralegal, because it says internal emails in relation to correspondence with the court.
Probably my drafting or my dictating anything that needs to be related back if there was ongoing communications, even if it was by phone call or email. It's pretty standard.
Are you guessing? Okay.
I didn't say I'm guessing. I mean, you could say that, but that's not what I said. But it's pretty standard.
Well, the word probably was the first word that came out of your mouth. So probably means maybe, I don't know, doesn't it?
Probably.
It's probably more of a certainty.
I said probably with phone calls or emails.
Oh, it
You
says
can try to
emails.
lock me in, but it's not going to work.
Then we have another 8.5 hours to get ready for a pretrial conference after I think we already spent 11 hours. Is that correct?
You're talking about two different dates, sir.
Right,
So-
but it's the same trial, isn't it? What happened to the 11 hours worth of work you
Do you
did?
practice family law?
I do.
Y'all aren't gonna
Practice
do this.
litigation, but my
You
question
guys aren't
is,
doing this. We're not going to
Okay.
do this.
Okay.
I was going to say something to you guys earlier, and then you both brought it back in, but
all right.
you have to be respectful to one another. We're not
Sure.
going to fight over Zoom. Okay, Mr. Shutt, you can continue.
Thank you.
Thank you.
These two motions here in January, you know where the emergency motion, you know whether you won or lost those?
I can't tell you if I won or lost them.
Arranging for a courier, multiple calls for estimates, review of emails. How much of that is clerical versus actual legal advancement of the case? This is
Wait,
the
can you
entry
ask
on
it again?
2-6.
What? 2-6. Aside from the arranged for the courier, which is scheduling, so I agree that a arrangement for the courier, although it's time spent, I mean, it is clerical, absolutely. But the calls to the JA, review of multiple emails from the opposing counsel is all meaningful work.
Okay. Is this draft of attorney charging lien, is that being included in the fees that you're seeking to add that the husband has to pay?
Again, I'm not asking the husband to pay. That's not, that's nowhere in my line of, this charging lien is against Ms. Gonzalez's recovery from the final judgment, what she owes. Yes, and the case law states that that time spent both to draft and to enforce a charging lien can be asked and billed, can be billed and asked in the recovery.
My understanding, folks, is that we're here today on two issues. Number one is the reservation of jurisdiction to determine the former wife's reasonable attorney's fees, which were awarded in the final judgment for dissolution of marriage. And Ms. Sparkman, you represented her there, so in fact, it was your request. And number two would be the amount of the charging lien.
Yes, and
they may be different.
I 100% agree with you, but Mr. Counsel keeps representing that I'm asking for this for the husband. I mean, it was my request for fees, but because of the complexity of how things transpired prior to the entry of the final judgment, the charging lien was sought against Ms. Gonzalez's recovery. So, I mean, I keep making that distinction. I understand what counsel is doing, because ultimately 50% has been ordered to come out from the husband. So I understand that part, but.
Well, but at the beginning of this hearing, Ms. Sparkman, when you began your proceedings, you did not indicate that any of the fees outlined in your billing statements were being only requested from the former wife. So my understanding, and I'm guessing Mr. Schutt's understanding, was that if you're requesting $34,075.80 in a charging lien to the former wife, that you're seeking the entire amount or one half of the entire amount from the former husband. That's how I understood it. I didn't understand that you were redacting any of this for the purpose of the award for the former wife against the former husband.
No. I'm not. I'm basing it purely on your order of the court. And your order of the court was that he's charged with 50% of whatever recovery of the fees that you ultimately award, right? So the entitlement, but then we're here on the reasonableness. So I understand that, but my only issue is the way that counsel's representing it is that I'm asking for it from the husband. It's not really, I'm asking for it from the husband. That's how it was ordered in the final judgment.
But you understand the court's, where I'm a little perplexed, because my understanding when we started this was not only were you seeking the entire amount of the charging lien as outlined in all of your billings, but that the request was that half of those fees be paid by the former husband. So I understand where Mr. Schutt's going with this questioning, because you may very well assert that drafting the notice of charging lien is properly attributable to Ms. Gonzalez, but Mr. Schutt's position is it's not properly awardable as attorney's fees to the former husband because it's improper under the law. So that's where we're headed, and I think it's not a difference without a distinction, it's a difference with a distinction. And I get it, so that everybody knows, I get it, I understand the difference. So Mr. Schutt, you can proceed.
Okay. The last two entries on this particular page, you have 8 and 8.2 hours, but can you expand on what that was for?
This looks like it's a trial. So these were incurred on the actual days of trial.
Do either of those time periods include travel time?
I don't think so, because if you look at the time frame, I mean, I know there was one day, and I know the court probably remembers, but I mean, I spent in excess of 3.5 hours, 4 hours in the car. So if you count the time, I don't think so.
Was one of the trial days a half day in court?
I don't think so. I'd have to go back. I'm sorry. I don't think so. There was a day that I was not there until close to 10:30 because I was stuck in traffic coming from Tampa, but I don't think we ever started in a half a day. I think it was each day was a full day, and I was supposed to be there at 9 a.m. that morning.
Okay, so the one you got there late for, did that go past 5 o'clock that day?
I don't think we ever went past 5. I can't be sure. I'd have to look.
So was this 8 hours in actual time, or just a guesstimate based on what a normal workday would be if we look at a 40-hour week?
No, I mean, the time that I actually spent, and there was time outside of just standing in the courtroom, just various things, trial issues that came up that had to be addressed for the trial in my presentation that I would have had to attend to. So.
I'm just going to put this on the record so everybody understands it. One thing I cannot do is I cannot award attorney's fees in connection with the representation of the former wife to the former husband after Ms. Sparkman, you withdrew. And I believe that you withdrew pretty quickly after the trial. I have to look, but it looks to me like some of your billings, for at least as far as the hearing today on the fees attributable to the former husband, it appears to me it looks like it's after you withdrew. I just want to make sure, because I thought you withdrew really quick in February. Let's see here. Judgment. Maybe I'm wrong. Maybe I am wrong. It looks like you withdrew on the March 2nd, maybe. Okay, so you're right. That's not, it's not after you withdrew. I thought maybe you'd withdrawn in February, but it looks like you withdrew March the 3rd.
Do we know if we have an answer, Your Honor, from Mr. Stein on whether I can send you the unredacted copy of the billing?
Mr. Stein?
You know, after reviewing it, we're going to maintain privilege.
Okay.
Your Honor, I have no further questions. Most of my basis regarding the attorney's fees is going to be brought up in legal argument based on the Florida case law on reasonable attorney's fees.
Sure. Mr. Shutt, would you provide me with this exhibit that you put up on the screen? I think it'd be helpful to the court to see what items you're contending are purely clerical. And then also, Mr. Stein, I have a question for you. How is it that I can determine the reasonable attorney's fees that would be assessed against Mr. Gonzalez for the entries where there are redactions? Because, you know, for instance, the one that's right in front of my face right now says research case on blank 4.5 hours. And if we're maintaining the redaction, I have no way to determine whether that is a reasonable entry or not. So it really leaves me with looking at that redacted entry and saying, I can't assess that because there's nothing there for me to make a determination on reasonableness at all.
Understood, Your Honor. And with that, I'm gonna I'll waive as you suggest, and just to let you know, our position is we want to ignore all those entries that we didn't have a hourly agreement, that those entries were done after the fact and we're essentially double billing and she's not entitled.
Well, wait, that's a different issue. I mean, obviously I have to rule on the issue of the charging lien and the amount of the charging lien, number one. But number two is I have to rule on the amount of the attorney's fees that Mr. Gonzalez should pay 1/2 of. And I have to make a determination as to the reasonableness, not only the reasonableness of the fee, but whether there were items that were charged in the billing that were line items that were purely clerical in nature. And in order to do that, I don't know that I can do that without seeing the full billings. I think I have to have the full billings to do that. If I don't have that, I'm going to have no other option than to strike those items where there's nothing informative to the court as being unreasonable, which may significantly reduce the amount of fees that the court awards or may not. I don't know. I'm going to have to take some time and go through all these billings, which I will do. But in order to be able to do that, I think I have to have the full billings. And if Ms. Gonzalez isn't willing to do that, well, then the consequence may be that a lot of these things that are redacted may just go away.
And she did waive, and I had jumped in and removed it without talking to her. So she's going to continue with the waiver.
Oh, with the waiver. Okay. Which means that you will provide me the non-redacted portion of the bill to review in camera, correct?
Yes.
Great.
So are you going to send that, Mr. Stein, or would you like me to send the copy that I sent?
I'll do whatever anybody wants me to do, whatever's easier.
And Tommy, you there?
Yes, I'm here.
Okay, so obviously this will be a trial exhibit. And I think we would mark it as petitioner's exhibit number 19. But after I review it, it's going to have to be filed confidentially so nobody can see it. Can we do that?
Yeah, we can do that.
Okay, perfect. All right, I understand the arguments from everybody in this, and I'm going to have to take both issues under advisement. Number one, because I do need to see the non-redacted billings and go through everything. I also need to review all of the exhibits that were admitted. And Mr. Shutt, I didn't hear from you whether you would be willing to provide me with this summary that you prepared that actually shows all of the line items that you're objecting to, because that would be helpful.
I did. I believe I sent the email to the email for Jennifer McAllister.
Wonderful.
And if I, for the record, can just state an objection to the husband not being able to see the unredacted billing statements for purposes of determining attorney's fees. I just want to state that for the record, that we object not being able to cross Ms. Sparkman as to those entries.
Well, offer me some solutions, because I do believe that the husband should be able to understand what he's being billed for, but at the same time, I have a concern that there may be some entries in there, that may disclose confidential communications between attorney and client that they may not want to share with the former husband. So I would think that there's got to be a way. There's got to be a way to.
I'm sorry to interrupt, but I'm okay. I'm being clear since the beginning and transparent. I don't see that it's nothing that my previous husband don't know about the case that I need him not to know.
So you don't care?
I don't care.
All right, then let's let everybody have it. And I didn't think you cared, Ms. Gonzalez. I mean, you've been pretty open throughout your trial about everything. So I would actually be surprised if you cared that he got the non-redacted, because you've been pretty much an open book. So, so with that, we could do one of two things. We could share the non-redacted billings right now with everybody and mark that as an exhibit. Again, I still think it should be filed confidentially when we do the filing as exhibit number 19. I could take a recess, give Mr. Shutt an opportunity to review it, and then see whether he has questions on the non-redacted.
I would appreciate that, Your Honor. I
Sure.
Sometimes need some more time to review things. I'm not as sharp as I used to.
Well, it sounds like all of us have been doing this for a very long time. So me as a lawyer and now as a judge, and it's just, I think it takes a little longer as we get older too. I had to judge a mock trial competition the other day where all these kids knew how to do all this screen sharing. And I said, you're better than most lawyers in the court about this screen sharing. Newer generation, they're a little faster and they got better technology. So, but I think we're doing all right so far. So do you guys want to share the billing with Mr. Shutt and then we could come back in 10, 15 minutes? Does that make sense?
I'm sending it to him right now, Your Honor.
Okay, because I'll give you time to take a look at it, Mr. Shutt.
Yeah, I've just got to compare it to what I was using to see, where the holes are filled in.
Okay.
It was just sent. And Your Honor, if I could just jump in with a quick thought.
Sure.
I'm not sure if I'm reading it wrong, but it sounds like, we're almost ready to wrap it up. And I just want to be clear. I plan on calling my client on a very limited issue and just probably need a few minutes with her, just so everybody knows.
Okay. Yeah. As long as we don't go past 5, because I'm not allowed to keep the clerk past 5, and I've already lost my bailiff. So, and my JA. So right now I have a directive that I can't keep people past 5 unless there's a real need to, and they don't like it.
Yeah, with that in mind, that's why I just wanted to advise you of my plan.
Sure. Yeah. No, I'll give you guys till 5. Strangely, I just looked at my calendar on this, and I think this actually was the last trial that I tried before the whole courthouse got shut down, and I'm now sitting here with an empty courtroom. So how bizarre is that? February 11th and 12th of 2020 was the last in-person trial that I had.
Wow.
Strange.
Mr. Shutt, you're still screen saving? I'm just, because sometimes I've kept mine on and I just don't want your entire system to pop up if you wanted to stop the screen saving.
Screen sharing, you mean?
Yeah, sharing, I mean.
Yep. I think we still have the billing with his notes up, which is what he was going to send over to me too.
Yeah, no,
There we go. Sabrina, I won't keep you past 5 either. How's that?
She's on mute.
Oh, sorry, I'm a goofball. I'm here for the duration. It doesn't matter.
All right.
All my babies are grown. Nowhere to
know.
go.
Oh,
We've known each other since we were little kids.
oh my gosh.
That's why
Yep.
she's my favorite judge.
Oh, that's awesome.
You're my favorite too.
Yeah, I only get you randomly.
I know.
You,
I- Did your sister tell you that I ran into her at Crystal River we were staying in the same hotel?
Get out. No, she didn't mention it.
Yes.
That's so
I'm going
funny.
down to breakfast and there she is. And I'm like, Missy, what are you doing here?
She didn't make you selfies. She's like a selfie queen.
I think she might have selfied me and it was way too early to be doing that. Yeah. Not at 7 a.m. when you're going down for coffee. You're like, oh,
Yeah.
don't do that.
I've had a chance to review them, Your Honor.
Okay.
We also added them to our exhibits, Your Honor, and sent them so that you have the copy as well.
Okay, thank you. Mr. Shett, do you have questions you want to ask Ms. Sparkman based on the newly non-redacted version of the billings?
I think they're fairly self-explanatory. I would probably most likely address them in legal argument based on the standards for reasonable attorney's fees.
Okay.
Just looking through them again, because I highlighted the differences, but nothing really snapped out at me.
Okay. Then at this point, are we done with the questioning of Ms. Sparkman? I know Mr. Stein wanted to call Ms. Gonzalez.
I don't have any, oh, sorry. I was going to say, I don't have any redirect or what, I'm not even sure what it is anymore, but I don't have any questions.
I'm not really sure either. Call it just continued questioning over Zoom. Zoom fatigue is my new term, I call it. All right, what about you, Mr. Shett? Do you have any more questions for Ms. Sparkman before we allow Mr. Stein to call Ms. Gonzalez?
I don't believe so, Your Honor.
All right, thank you. Then Mr. Stein, you can proceed with Ms. Gonzalez. And Ms. Gonzalez, I would ask that you unmute your microphone at this point.
Yes, I am.
Okay, Mr. Stein, you can proceed.
Ms. Gonzalez, who was the first attorney you hired in this case?
Mrs. Denise.
What was her name?
Denise Gann.
Denise Gunn, thank you.
Okay, and did you sign an agreement with Attorney Gunn?
I did.
Do you recall what type of agreement it was?
Yes, it was a flat fee of $5,000, and she provided me with a payment plan, which is outlined in the contract that I provide to you.
And can you look at Petitioner's Exhibit 16?
Don't ask.
Okay, so do you see under, on the, really the first full paragraph on petitioner's exhibit 16, the entitled attorney's fee?
Oh, for Mrs. Sparman.
For petitioner's exhibit 16 is an attorney fee and cost agreement for legal representation. It's from Attorney Gunn.
Oh, yeah. Sorry. Attorney fee here. Yes. Yeah.
Okay, and is it your understanding that that 5,000 was a flat fee?
Yes, it's very clear. They are agreed to pay a sum of 5,000 as a flat minimum fee.
And do you know what that flat fee covered?
Yes, she explained to me that was her representation. And
Okay, but she stopped representing you at some point. So how long did she represent you for?
I think 5 months.
And did you pay the entire 5,000?
Yes, I did. There is an outlining of the payment, that same package, where it shows when I pay her, how she was deducted.
Okay. And
Sorry, Juliet, I can't really hear you. Would you mind getting closer to the mic? Thank you so much.
Okay.
And Ms. Gonzalez, did you say that you have paid the 5,000 in full?
Yes, I did.
And just to be clear, Attorney Gunn represented you in the divorce case with your husband, correct?
Yes.
And that was before Ms. Sparkman, correct?
Yes.
And do you see in, let's see, hold on, let's give me 1 second. Who's Stephen Baker?
He was hired by Mrs. Gant, Denise Gant, as the accountant.
And did you pay any money to Mr. Baker directly for consulting fees?
No, directly at that, when I was with Mrs. Gant, everything went through Mrs. Gant, and she gave me a contract with him. And it's also the one that I give you there. And he outlined his fees.
What was he in? I'm sorry, go ahead, continue.
He outlined his fees there in that contract.
What was Mr. Baker an expert in your case?
I don't know how, I don't understand that. He was the accountant for my case on my side.
I'm sorry, a little louder, please.
Yeah, Ms. Gonzalez, we can barely hear you.
He was the accountant on my case, Mr. Baker, and Mrs. Sparman contacted him a couple of times, and he was to show up on the trial day, but then she canceled him without my knowledge.
And were you charged separately for Mr. Baker?
Yes, he charged me, I want to tell you exactly the amount, $9,275.
Okay. And was that in addition to what Attorney Gunn charged you?
Yes.
So how much total between the Mr. Baker, the consultant, and Attorney Gunn for the first part of your case?
$14,275.
And then, as far as I'm concerned, when did you hire me?
Just a few weeks after the trial. I don't remember exactly the day, but it was in March. March.
Did what kind of arrangement did we have?
We have a flat fee arrangement as well.
Okay, and how much did you pay me for the first part of the representation?
1,500.
Okay, and is it true that there was additional work that wasn't anticipated when we first started?
Yes, the RB issue. That was
Okay, and did you end up paying me an additional flat fee for the extra time in the case?
Yes, sir.
How much was that second one?
900.
So you paid me a total of how much?
2,400.
Do you owe me any more money?
No,
Do you expect to have any further bills from me?
we have no conversations that will make me think that you need more money from me.
Okay. Now, as far as your representation by Attorney Sparkman, when did that start?
Experiment back on June
What year?
2019.
Okay. And what kind of an agreement did you come to with Attorney Sparkman at the outset?
We start with a contract of retainer, which she asked me for $10,000, and I give her $5,000. But she went and looked into the case, and she found out that my case was in a trial schedule already. It has the pre-trial trial schedule. So she came back to me and said that because my case was in that stage, she needed to change her fees to $25,000 instead of doing the retainer thing.
When she changed the 20 to 25,000, did you talk about getting itemized billing and hourly billing or something else?
Well, she sent me, I asked her, okay, I will need itemized billing for the $5,000 that I give her. And I have provide you the, I think it's in Exhibit 2, where I asked for that information. And
I'm sorry, you got muffled. You said, did you mention exhibit?
Okay, where I asked her, so please to provide me with the, outline. My question, my words at that time were, I'd like to ask you if you can please send me a today detailed report on work already billed. I got a little scared when you told me the first 5K were already gone. You know this is a loan, and I had to make it sure it goes a long way.
Excuse me, are you reading from something?
I'm reading from my messages with her.
Which, can you identify what exhibit that is so everybody can follow along?
Exhibit 2.
Exhibit 2, it's, Your Honor, that's our petitioner's Exhibit 2.
Okay, thank you.
Okay, I'm sorry to interrupt. I just needed to get that on there if it wasn't clear.
And then she answered, yes, so the 5K I will send you, Bill. This new retainer is a flat fee for trial, so it's different, but yes, we will send you, of course. Give us a few days into next week to do so, as girls are working in Sunday lines, but she never sent it to me, ever.
Okay, and did you pay that flat fee?
Yes, I did.
Was it your understanding that that flat fee replaced the former agreement?
Yes, yeah, that's what she wrote there, that it replaced.
After you paid that flat fee of $25,000 and the $5,000 down on the initial retainer, did you expect to receive hourly billing statements and requests for payment for hourly billing in addition to that flat fee?
No.
When was the first time you were requested to make payments on an hourly fee?
It was in December 2020.
How long after that
like
What amount of time transpired between when you paid the $25,000 for the flat fee and when you started receiving a request for hourly billing?
Well, I had to clarify something. It wasn't a request for hourly billing. It was just another bill, which I asked her to clarify why she's billing me. And you can see that in exhibit. So the first email that she sent me was.
What exhibit number is that?
Exhibit 3. So I didn't hear anything about fees with her until this day, which is an email from the law, Sparman Law, and it says, you know, happy holidays, but I reviewed your file recently, brought to our attention that your retainer is expired. We are at the stage that will require replenishment amount of $7,500 to be paid on or by January 1st. And that's all I heard. So then I questioned that.
Well, let me jump in for 1 second. Did you receive a billing statement with itemized billing after that?
No.
Well, I'm listening to me carefully. In February 2020, weeks after that, is that when you first received an itemized billing statement?
Yes.
And so they were asking you to replenish your retainer, but you didn't see where the money had gone, correct?
And I didn't even knew that I had to replace a retainer. I wasn't a flat fee.
I understand. So at some point, did you have any discussions with with Attorney Sparkman about what the flat fee covered, or about reverting back again to a hourly billing?
No, sir. I requested, if you can see, Exhibit 4, Exhibit 5, Exhibit 6, Exhibit 7, and emailing these lawyers so many times to clarify, because I to clarify where is this coming from. I didn't get an answer.
So after you paid your flat fee, you're requested to replenish your retainer. At any point, oh, I'm sorry, let me withdraw that. I lost my train of thought. I apologize. When was the first time that you were asked to convert? I'm sorry, I'm going to ask it this way. When you were asked to convert back to a hourly agreement, no, I'm not asking it right again. Let me try one more time. I apologize for fumbling. Isn't it true that when you asked for itemization after you were asked to replenish the retainer agreement, you were told that that was going to cost you more money? Is that correct?
Yes, that's correct.
And was part of the increase in fee just the accounting of the work? Is that true?
I don't understand that part, the second part.
So I couldn't hear your answer.
Sorry, I can't hear you.
Would you ask that again, please?
Yes. Was part of the increased fees that Attorney Sparkman was indicating that might be involved with itemizing, was part of that the actual accounting of it?
Was part of actually accounting.
In other words, what I'm trying to say is, did she say she was going to have, your fee was going to increase because now I got to document
Yes.
billing?
That's what she put in her email that I put it in exhibit at I think 10. That she has to go back and do all of that or doing the stuff. She's going to charge me.
And you didn't ask her for itemized billing until she told you that you need to replenish your retainer agreement, correct?
Or this, yes.
Because you didn't expect there to be any need for itemized billing because you thought you're on a flat fee, correct?
Exactly.
So is it your understanding that essentially you were paying her a flat fee, correct?
Yes.
And in December, when she sends that email about replenishing, she also wants to get an hourly rate in addition to the flat fee, correct?
Yeah. Yes and no. She didn't really talk ever of an hourly fee. She just keeps sending me amounts. Like if you see my exhibits, she went and one went to 7,500. Then there's another email is 15,100. Then the next email, she said, if I don't get a continuous, and I had to go through the trial and the days that the court said, it will be then, it will be 15,000, but if she don't get a continuous, it will be 25,000. So there wasn't hourly rate. She just keep adding these numbers and coming, and I just like really lost, like what she's doing to me. It's like it will sound like threatening, or I leave the case, or you can read it in the emails. Because at one point I just decided to just put everything on writing. Okay,
and did you agree to go back to the hourly rate?
Never. Because never, that will not. It was not the way I've been practicing since I did this, because like she said, my financials were very, very poor and I lacked all the money. So I couldn't agree to something that I don't know where I'm gonna go.
And when you got your first statement itemizing the hourly fees incurred, what period of time did that first statement cover?
Since the beginning, since the first time she itemized our agreement.
So when was the beginning?
She started with an email to client with retainer engagement. She put it as a 423.
Okay, and when did you sign the agreement with Attorney Sparkman?
I got it.
Wasn't it in June 25th, 2019?
Yes.
So you pay her a 25,000 flat fee at some point, and then she goes back and starts billing you, or she goes back in, the statement is from February 8th, 2020, and it includes dates starting April 23rd, 2019, 2 months before the representation starts, and it goes right up until, let's see, I think it goes till the February 8th.
Yeah.
Is that correct?
Yes.
And so the 25,000 you paid for a flat fee covered that time of that April 2019 through February 2020, where you also got hourly billing charged to you, correct?
Like I said, I got another bill for 7,500.
Okay. I don't have any further questions, Your Honor.
Okay. Mr. Shutt?
Can I cross-examine or just?
I'll give
She
you an
can go
opportunity
first.
to. Do you want Ms. Sparkman to go first? Sure, Ms. Sparkman.
Sorry,
you can proceed. That's okay.
Ms. Gonzalez, isn't it true that you didn't pay Ms. Gunn the remaining balance that you owed her firm?
That's not true.
I'm going to object to the relevance of that.
Well, it's very relevant. Ms. Gonzalez formed agreements with several professionals and then refused to pay and comes up with the same excuse for each one, including her former counsel.
But I don't think her refusal to pay is an issue. Is her refusal?
Hold on, one at a time. Okay, and what was your response, Mr. Stein?
I don't think the refusal to pay affects any of the issues today, if in fact it was a refusal to pay.
I'll allow it. Overruled. You can answer.
In fact, Ms. Gunn was involved in a very difficult hearing on your behalf in which she was stuck in the middle of an accident and couldn't attend. Thereafter, sends you an invoice for the time she spent, and you never paid that remaining balance, did you?
Like I said, I paid her in full. She charged me like $250 every 2 weeks because she knew my financial situation. So every time I got paid, I knew that from that check, 250 went towards her. So it was easy to pay 250 every 2 weeks. And
what I'm saying is, after you terminated her, and after I filed my notice of appearance in this case, you did not pay her the remaining balance, did you?
No, Mrs. Farmer.
Okay. What about the PA?
Let her finish the answer.
Wait, one at a time. One at a time, people. I can't hear it if you guys talk over each other.
As far as the CPA, you owed CPA money and did not pay him what he was owed, and therefore he wouldn't testify in this case. Isn't that true?
No, it's not true.
Your current attorney examined you on the signing of the retainer agreement and that the date you actually hired me. Isn't it true, Ms. Gonzalez, that you actually retained my firm on April 24th, 2019, but were unable to actually sign the written retainer, so sent an email with your name and signature on that email acknowledging that you accept the terms of the retainer agreement? Isn't that true?
I don't remember what you're talking about. Sorry.
Okay, well, let's turn your attention to my exhibit number 1.
Yeah.
Scroll down past the retainer and you will see your email with your signature. April 24th, 2019.
You're talking about this?
Yes, ma'am.
Okay.
What is the date? What is the date on that email?
Email.
The document you just had in front of you.
I'm looking. It says April, the email says April 24 because I'm clarifying.
All I'm asking is the date of the email right now.
Yeah,
What is the date?
I'm clarifying our travel fees agreement, and that was April 24.
Okay, April 24th, 2019. April 24th, 2019 was the date that you retained my firm.
No,
what
it's
was the date?
Clarification for the travel fees. It's no.
Ms. Gonzalez, what was the date you actually signed the written retainer contract?
Oh, it's here in the contract.
What was that date?
6/25/2019.
Say the first word again, please. You cut out.
25/2019. That's
June.
when I signed.
June 25th, 2019, correct?
Mm-hmm.
Okay. Isn't it true that you did not pay the full $10,000 that was outlined in the retainer agreement, but you asked for that to be paid in a payment plan and I agreed, correct?
Correct.
Isn't it true that in preparations of the first hearing, you, myself, and Ed had a discussion on the hourly billing and what I anticipated billing and had already billed, in which you asked me to send you a statement in that first month of discussion that we had, Do you remember that?
I remember that you told me that and you asked me for $25,000 because you changed it to a flat fee. And
Ms.
that,
Gonzalez, at that point that we had that discussion, had you even paid your full retainer? You'd only paid $5,000.
no, I didn't pay it because you changed it. So,
And Ms. Gonzalez, you showed an email just a little bit ago. Were you not challenging me during that phone call that you couldn't believe that 5,000 of the total 5,000 that you had paid had already been spent on your case? Do you remember that?
the text, yeah, said that.
Okay. And during the phone call, didn't you express the same thing that you expressed in the email, that you were shocked that 5,000 of your 5,000 paid had already been spent? Do you remember that you expressed your shock?
It wasn't no phone call. It was the text message.
Okay. Do you remember a phone call that you, myself, and Ed had regarding the fees?
No, I remember the text message, and then we agreed how we're gonna pay the 25.
And we agreed during a phone call after hours regarding the billing statement to date at that point, correct?
No, we saw, you sent me that, then you sent me an email, which is in a exhibit, I think, 2, that says that you want me to send an email to the office, that you agreeing to pay 25,000 K, and you're gonna bring.
But that agreement was made during a phone call in which you expressed that you cannot continue to be billed on an hourly basis for this trial that was set. Do you remember?
I'm sorry, say that again.
You keep referring to the agreement that we made regarding the $25,000 fee towards the trial. That agreement took place during a phone call in which you were displeased with the amount that was already billed at that point.
I don't recall that.
Okay, well, the agreement took place by a phone call. Do you agree with that?
No,
Okay.
it wasn't writing.
Ms. Gonzalez, at some point, did you ask me to delay this trial as long as possible because you were moving?
Well, let me tell you something, Mrs.
No.
Wait a minute, Ms. Sparkman, you asked the question, you let her answer. Did you delay it, Ms. Gonzalez?
No, my situation, economical situation was so bad that I wanted a trial yesterday. And this keep moving and keep moving. I'm so grateful that the court finally pushed it to happen.
Ms. Gonzalez,
in the same situation.
did you ask me to delay the proceeding during your move to Arizona so you could settle into the new job that you had?
What I asked you is to make sure that the days are known when I start in my new job, because I will not be able to do that.
Ms. Gonzalez, wasn't the first date of the trial the date that I anticipated and that I was hired for to go forward on delayed because you decided to move right before the trial date to Arizona?
No, I have never moved to Arizona until the end of my trial in 2020.
Maybe I'm using the words move. Wasn't it anticipation for your move? You were spending extended periods of time in Arizona and could not come back to Tampa for the trial. And so you asked me to extend it. Isn't it true?
It's not true.
Isn't
I
it
was
true?
going to a surgery, as you were very aware. Okay, and I have a job in Florida.
Ms. Gonzalez, for all of the reasons, every reason that you had, those reasons that you gave to me are the reasons that that first trial was continued. And isn't it true that the very following month, I sent you the statement that you would need to pay the firm for us to continue providing legal services, which your attorney just examined you on or about December of 2020?
Mrs. Sparman, you're lying.
Ms. Gonzalez, I'm asking you the question.
You just testified that in December of 2020, this is your testimony. You testified that in December of 2020, I sent you a statement asking to pay X amount of dollars. Wasn't that not even a month following when the trial date was set?
We didn't know when the trial is going to be set. Remember, they set it for you because you never said one. The court was have to hear with the representation that my ex and I have with this case. It was like 2 years trying to go to court.
Ms. Gonzalez, I was not representing you for 2 years.
You go to the appointments, it was something else with your case, it has some kind of the line, and I was really wanted to have a case. Like it was always something.
Ms. Gonzalez.
Even for the last trial that we have,
Ms. Gonzalez, I'm objecting to non-responsiveness. I want to make sure.
Hold on. I'm not going to let you two ladies duke it out in my courtroom. You guys want to do this, you do it somewhere else. We are bordering on inappropriate. So you guys both need to take a deep breath and tone it down, because otherwise I'm going to end the proceeding. We have 16 minutes left. I would suggest that we ask questions that are relevant and keep the tempers down. All right. Ms. Sparkman, you may ask your next question.
Isn't it true, Ms. Gonzalez, that by the time that the February trials were set for hearing, you and your boyfriend, Ed, agreed to remit the payments that were owed to the firm within 15 days of that trial fee?
Not true.
Ms. Gonzalez, did you expect a lawyer to work for free for you from the time that that first trial was continued to whatever future date that that trial of yours was going to be set for? Is that what your expectation was?
My expectation was getting the job for the flat fee that I was charged for.
And just like you didn't pay Ms. Gunn, you didn't pay my firm, and you didn't pay the CPA.
I'm going to object that hasn't.
Hold on, there's an objection. What's the objection?
The foundation hasn't been laid for whether she paid Ms. Gunn or not. There's no testimony. She's putting evidence into the question. It's not an evidence.
And I believe the question's already been asked and answered, so it's sustained.
I have nothing further.
Okay. Mr. Schutt, you have some questions?
Yes, just a couple, Your Honor.
Thank you.
I want to go back to the CPA, Mr. Gunn. I was not at the trial. Was he hired to testify at the trial?
He was scheduled to go at the trial, and because Mrs. Sparman and I have issues during the trial, she canceled him without my, agreement. And I know this because I called him when I was in trial, and I said, "Why you're not here?" And I said, "Well, she called me and said not to show up." And I'm like, that was on the things that she did that day against me.
Okay, and so just to clarify, to make sure I understand, he did not testify at trial on your behalf, correct?
He couldn't show up because she canceled him.
Okay. And has he sued you for any payment?
No.
Has he written you any collection letters for any payment, or said he's waiting on money from you?
No, we have a payment plan.
I'm sorry, we have a what?
A payment plan.
So are you paying him?
Yes, I'm paying him $300 monthly.
And are you paying him the full amount that's in the bill or a negotiated amount?
He's being very kind, just paying him the 300, but just paying him the 300 full amount. Until
How much have you?
Full amount.
How much have you paid him to date?
I had to look at his last invoice. How much is left. I don't recall right now, like exactly amount. I can email you his invoice.
Do you have any detailed invoices from Mrs. Gunn when she represented you?
No, because that was a flat fee.
But she didn't give you a statement of what she had done in time spent at any time?
No, that was a flat fee. Never was discussed on such a thing.
No further questions, Your Honor.
Okay, thank you. Any other questions from anybody else at this point? I think we've heard a lot.
Your Honor, if I could just have one question to clean something up, well, maybe two questions. It's just to
Sure.
clean something up.
Go ahead.
I have an exhibit that's marked petitioners 18, and I did leave off the Baker consultant. And actually, when the question was asked, I think the name Gunn was inserted for Baker, and Mr. Schutz was just asking the question about the consultant. Consultant is Baker, the attorney was Gunn, and the attorney Gunn's fee on my petition is Exhibit 18, which is just demonstrative evidence that I created. I made a mistake, and I apportioned $9,275 to Attorney Gunn, but that's actually Baker's fee, and
I saw
Attorney
that.
Gunn's fee is $5,000.
I saw that. I saw the fees. They're in one of the exhibits. I already reviewed them.
Okay, I just wanted to clear that up. Thank you.
Thank you. Okay, folks. Well, we are nearing the 5 o'clock hour, which means that we have to wrap it up at this point. I am going to take this under advisement, both of the issues, and I will give you guys a written opinion. I do also want to review the non-redacted bills that have been submitted to me together with the exhibits. I did receive a bunch of case law too. I'm not sure what the case law says, so I'm going to take a look at that too. My judicial, I almost said paralegal. My judicial assistant just gave me a big old stack of stuff from Lexis, so I'm going to take a look at that as well. I usually have my opinions done within a week. Okay.
Your Honor, since we don't have time to make closing arguments, and most of my arguments are legal, is it permissible that we submit a written closing argument?
If you'd like to. I mean, I do think that I understand a lot of your argument just from the way that you've asked the questions, which are that a lot of the billings are confusing so that you can't delineate between the clerical and the legal. And in fact, a lot of the billings that are there are purely clerical and should be redacted. Are there other things that are contained within those billings that you want the court to consider? I mean, I'm happy to have you submit written argument if you want to, but that was the gist of what I was getting from your argument with respect to Ms. Sparkman's billings, is that a significant portion of them were clerical, and that I'll see that highlighted in the billing that you're going to send me.
One of the things was with the unredacted portions that were the previously redacted but yet unredacted portions. And the reason I didn't address them too much is they basically describe numerous emails on weekends, nights, after hours, and whatnot. And there is a Radford versus Valley Homeowners Association that addresses how much time is necessitated by the client's behavior. In other words, if you have a client that requires a lot of hand holding and everything else and more than normal, that the court has to take that in consideration when assessing reasonable attorney's fees. It's something that doesn't come up a lot. I think this is one of those cases, and that's what kind of jumped out at me when I reviewed the unredacted portions of the timesheets, because it just seemed like there was a lot of numerous calls, emails, hand holding, listening to videos from the boyfriend, stuff like that.
I will definitely take a look at it, but I will tell you that I remember this trial very well. It was a long-term marriage, and there were a lot of things that were difficult for the former wife. So I'll have to take a look at them and determine whether I think they were excessive based on what I know of this case. It wasn't a simple case, and she, the day of trial, was very upset throughout most of the proceedings. And I, understand that there are some circumstances where a person may be a little more upset than others going through the divorce process, whether that equates to excessive hand-holding or not. I don't know. I haven't looked at the bills yet. I mean, there may be some of that. I just don't know. I'm not going to prejudge it without looking at it, but I think that I have to think about that in the context of this particular case and these particular set of circumstances and facts and the individuals that I saw in my courtroom. And I do remember that it was very, very difficult for Ms. Gonzalez. Part of the difficulty was that Ms. Gonzalez and Ms. Sparkman had a terrible working relationship. And I had to decide as a judge, do I allow Ms. Sparkman to withdraw on the day of trial and allow a woman in a long-term marriage to be self-represented? Do I continue a case that has been continued at least once and maybe twice that needs to be tried? So despite that difficult attorney-client relationship, which we've seen again here today, I forced it to trial. So I may look at this and find that maybe there was some excess communications that had nothing to do with the case, but rather had to do with the fact that these two have a terrible relationship. And I certainly don't think that I should make the husband, the former husband, pay for the fact that these two ladies don't get along. But again, I'll have to look at the billing and see if I find some of that in there. I certainly now have all the information about when the attorney-client dispute was going on with respect to the money. And if there's billings that I see that I think are related to the fight about the money, I don't think I can assess those against the former husband. So again, I have to look at it, but I am going to look at it very carefully. So I will try to get an order out to you guys within a week. I've got 3 big ones right now I'm working on, so it may be a little more delayed than that, but hopefully not. And again, if anybody wants to send me other cases, or if you have things that you think that you want me to consider, just put it in a short, you don't have to write a full written memorandum of law or anything. Just say, these are the points that I think we want to hit, and here's a case on point, and I'm happy to look at it. Because I'm not going to get this done, within the next few days, I can tell you that. More likely a week.
So
okay?
Like a closing argument or a memorandum of law can be submitted then?
Sure, happy to consider it. I just, I'm also happy to just have somebody send in a bullet point that says, these are my points, 1, 2, 3, 4, 5. Here's what I think you should look at. Here's the law, so that you don't spend, hours and hours writing a 10 or, page memorandum of law. I'm perfectly fine to have you guys say, here's the point, here's the case, and I'll pop it up on Westlaw myself, or send me the case and I'll read it. Whatever's easy. I think a lot of time has been spent on this case already. So if you guys want to spend the time to do more briefing on it, feel free, but my position is you don't have to.
Your Honor, may I have a quick 20 seconds?
Sure.
Of
course. Yes. I
want to make clear, we have potentially alternate theories here on for my representation of Ms. Gonzalez. But the main point we're trying to make is not what's reasonable and not reasonable as far as the lien. It's just that we had a flat fee. That's what my client understood, and you can't have both at the same time, and it looks like we had both at the same time. Thank you, Your Honor.
I knew that was your argument. I got that loud and clear.
Thank you,
Loud and clear, for sure. And Ms. Sparkman's position is, no, there wasn't a flat fee. There was a flat fee for that first trial that got continued because of Ms. Gonzalez, and once it was continued, she wanted me to do a whole lot more work that wasn't contemplated, and that's why the additional fees erode. So I get everybody's position. I just have to, I got to think about it and look at everything and come up with a decision, which I will do. All right. It's a few minutes before 5, and I think that this is the time to conclude this hearing. Thank you, everybody, for appearing today and getting this done. Tommy, we good?
We're good. You'll get those exhibits to me?
I will, but it's probably going to be with these a week. I got the first set of exhibits to you from the other hearing the other day. Now I've got the second one I'm working on, then this one, but you will have them. I've got them all in a stack, and they're in a clip, so I'm not going to lose them, I promise.
The court did receive the unredacted billing, correct?
They would have